Talk shoes. Recorded live.
Well, hi everybody. It's August 18th. Tonight our special guest speaker is Dean Clifford from Manitoba. You can find his YouTube channel is Manitoba. What is it? Free Manitoba. And your website is that freemanitoba.com?
Yeah, it's the website for one of the guys that comes to one of the classes here in Winnipeg.
Oh.
So.
Okay. Hi, Dean. I'm so glad you made it on after 37 minutes.
It's the black helicopter floating over my office. I swear to God, they're stopping my computer from working. So.
Oh, okay. You too, huh?
Yeah.
Yeah. I swear, I think they put the kibosh on my cable speed because everything slows down when I do these things. And
well, geez, no, I got a nice computer and everything here, and I uploaded that Pro version, and I was on the Pro version, obviously, in the chat window, but then it's still telling me I wasn't connected, and every time I pushed the connect button, it just took me to get a new PIN, which brought me back to the same window where I was not connected again.
that is so weird.
So who the hell knows what was going on? I don't know.
Yeah, maybe the next time you try it, it'll be cool.
Ah, well, it's all right.
I don't know. Anyway, I've been speaking about you all week long. I think everybody's seen your video series and is really turned on to what you got to say. You seem to put everything in such a nice, neat package. Why don't you, for those that don't know who you are, why don't you give them a little rundown of who you are and where you are and how you arrived at your great assessment of what's going on here.
Yeah, I don't know how great it is. I mean, everybody seems to be definitely kind of getting in tune with it because it is just that. It was simplified. I got so frustrated with everything that was going on online and all these theories and all the UCC stuff and truth talk and all these other truth language and everything else going on the internet that not one theory seemed to actually have any solutions. And I've been fighting this for 15 years now. I think I still have my last income tax filing I did back in 1996. So my battle started the same probably as everybody else, which is usually with a problem with Canada Revenue Agency. And then you fight with them for a couple of years not knowing what's going on until the internet, thank God. I think one day I finally came across Eldon Warman's site for DTax Canada. And that was my first introduction to the fact that the name on the birth certificate wasn't me. And I think my whole world almost collapsed that day. So since then, it's been a long path to looking what other people are doing on the internet and following theories and deciding that things just don't hold water. And then I think about 2 years ago, because everybody ends up operating off other people's work, right? We're operating off of other people's conclusions, and we don't know that the conclusions that they came to were correct. And so we were operating on a lot of improper presumptions in some of the court stuff we were doing here in Winnipeg. So we just decided we had to go right back to the drawing board because we couldn't trust any of the information we were working off. And that's what made us break everything. And so we decided, well, okay, to start from square one, let's break this down all right back to the very beginning. And we did. And then when we finally looked at the whole picture we'd painted by breaking everything down, we just went, holy shit. Well, now we know what's going on. Well, now it's going to be easy to proceed. So I think that's really my history. Other than that, I'm a contractor here in Winnipeg. I was building houses and doing renovations for a number of years, buying and selling some houses, and this seems to have taken over my life more recently, though. So I think this is the path I'm on now.
Yeah, we can all relate to that, I'm sure. So how did you arrive at your process or your understanding?
You know, it's weird. It's actually when I started teaching it, when I had to start figuring out how to teach it to other people. That's what, well, how am I going to understand how am I going to teach people what's in my head? So I'm like, okay, well, I got to draw it out for them. I'm like, okay, well, how do I draw it out? And I'm like, well, people have to understand that the name is an express trust, okay, and they have to understand that there's roles that are implied with an express trust. And then I had to start drawing it out because people like to see pictures. And the weird thing is, as soon as I started teaching it to people and drawing it in pictures, it even became more clear in my head. So every time I taught, it actually just became more and more clear in my own head as well, and just every new theory just kind of sprang from that, because once you understand what's going on, it's not hard to start to address the issue and figure out what's going on here, and that is contract law. Everything's contract law. I mean, everybody wants to say, you know, it's all to do with trusts, and it's all to do with trusts, and I mean, that's correct, but really, where do you even get the trust from? That's all a contract. So everything is a contract.
Right. And so when you get a letter, or let's see here, I have a list of things here I wanted to ask you, so let me get right to that.
Yep.
So we're in the United States. Most of us here are in the United States. What would you do in the United States? I mean, is it the same situation? Do you write a letter? What kind of a letter? These are notes that Alim, do you know Alim? He's the one that put
Yes.
us in contact. He sent me some notes, so let me just start with those. How do you deal with these people, these IRS agents and, government officials or imposters?
I know without even looking at American law that it's all based on the same premise, and that is literally just going by the maxim that no man has authority over another man, right? Nobody has authority over you. Everything has to be contract law. So in order for you to owe the IRS money, if they're claiming to collect revenue on behalf of the U.S. government, there has to be a contract in place for that. And then people would always tell me, well, the birth certificate is the contract. And I said, no, it can't be because there's no terms, conditions, there's nothing in there. All that you did was filled out a particulars of live birth when you started that. I said, so that has no foundation in law. There's no argument there. They can't provide joinder. Something else has to be going on here. And then it occurred to me, well, okay, if for government to even talk to a man, well, they can't talk to a man. They had to get us to create our own commercial entity, if you want to call it that, a vessel. Agent in commerce is a beautiful one that I've heard people call it. I think that's great. It is your agent in commerce. It's the most descriptive and perfect term there is for it. And then people would also tell me, well, no, the government created that. That's not yours, and that's just a load of crap. That's not true. If the government created it, then they could create it without you, but they can't. It's something you created with your own signature and or your parents, which is yours. That is your signature because you're the heir to that estate. So the government got you to create an agent in commerce. Everybody thinks that automatically grants the government jurisdiction over you, and it does not. I don't care what anybody says. I know that's true because I've walked out of court very, very successfully against criminal charges, and I haven't heard from Revenue Canada in 15 years, based on a very similar argument that I made 13 years ago that I didn't know what I said to the guy when I went to a meeting. But if you look up the word register, even in Black's Law Dictionary, all register means is a public fact, just a recording of a public fact. That doesn't mean you're actually registered with the government as in a government agency. It just means that there's a public recording now of the fact that this agent in commerce exists out there that the government can interact with. Beyond that, everything has to be a contract. And when we started ripping apart Canadian laws, and everybody has to understand all the work that we've done, a lot of it especially, a lot of this is work on the shoulders of giants. There's a lot of people out there that years and years ago have done a lot of the groundwork when people like me were still believing that we were taxpayers. And we try to work off that. So there's other people out there that have done the research and they've gone through and they've provided the information going through the Criminal Code of Canada and all the Canada Evidence Act. I think episode 6 of one of my videos there, the sit-down talk, where I'm just talking with people, I explain that if you go through the acts and statutes, you don't need to, but if you want proof of everything we're claiming to, it's all here because the Canadian government itself says in their own statutes that they only have jurisdiction over their own business. That's it. Which is obvious. That's a maxim of law. That's a maxim of equity. You can only have jurisdiction over anything that's your own business. So what the government's done is they got you to believe that everything that your agent in commerce does is a function of government. And that's a presumption. It's just not the case. And that's where I came up with the argument, well, okay, if that's their presumption, then I guess they have no problem providing a contract where I agreed to work for a certain wage or a payroll record where I performed a function of government and they compensated me, because that's one of the three fundamental principles of contracting, right? You have to have consent, you have to have full disclosure, and you have to have valuable consideration, which means I was paid for my services. And the only way I could be paid for my services by the government is through the public payroll, public money. I have to be paid with public money. The government can't pay me with anything else.
What about benefits and privileges?
I don't believe in any of that stuff. Not everything the government gives you is a benefit or a privilege, right? And here's the reason for that. Number one, everything the government has, they got from us. Government has nothing of its own. Everything they have is ours already. So them giving me back something that's already mine is not a benefit or a privilege. It's already mine. They just administrate everything on an administrative level and take a percentage for fees for administrating everything they do. So government can't take $100 from you and then take $25 of it for administrative fees give you back $75 and say that's a privilege. It's not a privilege. It was yours in the first place. Now you only have 3/4 of what you had in the first place. So it's not a privilege at all. If anything, you've extended them a privilege. We have to, everything, I found we had the most success when we looked at every situation going on out there and we flipped it around 180 degrees and said, well, this makes more sense. Is government extending us a privilege, or are we extending them a privilege? So it turns out now that everything, and my theory on this, and I have 100% faith in how correct it is everything that the government does is a privilege we extend them to do business on our land, to conduct commerce, to interact with us. That's a privilege that we extend them, not the other way around. That's the way people have to start thinking about it. They have to rewire their brains to understand that it's actually us. We are the ones extending the privilege, right? That's what creditors do. I'll let you ask a question from there, I guess. Hello?
Yeah, I'm sorry. I had my mute button on. I was talking to myself.
Oh, that's okay.
So what do you do then? You write a letter? What kind of letter? A notice? Affidavit?
Okay, well, yeah, if it's the IRS bothering you, that was the background on if you want to call it an argument that I'm making now. But if the IRS is contacting you saying that you're required to remit taxes for the legal person, right? Well, number one, you can't just be obligated to remit taxes for a legal person. There's got to be a contractor. There's got to be a reason why they want you to remit taxes. Probably because they're claiming you perform some function of government, and they have the jurisdiction to tax anything that does business with the government, right? That's just taxation on something that's under their jurisdiction. And that would be anything performing a function of government, anything contracting with the government and being paid out of public funds. So that would be a first contact with the IRS. You would contact them and say, well, hang on here, I'm sorry, but are you claiming that I've performed some function of government that creates an obligation to file taxes with you? There's nothing they can say to that. And if they say, well, no, say, well, then what do you want? Why are you contacting me? What makes you think I have to file anything with you people? You can't force me to contract with you.
So you do that all on paper. Is there, a particular size of paper that you use?
I used to think it was important. I remember one time the government got back to me with a response to something, and they said, thank you for your correspondence. And I said, oh, correspondence? I said, no, that was a legal document. And I'm like, oh, okay. Well, fine, maybe I should resend it on legal-size paper. So I started sending a whole whack of stuff off printed on legal-size paper. I don't think it makes any difference. I think if you're in banking and you're printing actual legal documents that between two parties, maybe that's really effective. It's not necessary for just correspondence back and forth between the courts. In fact, if you go down to the courts when you go to file a lawsuit in the United States, I'm not sure if that's district court or what that is. Up here it's Queen's Bench or Superior Court in Ontario. You can't file any papers on legal size. It's all got to be on regular size. Only your exhibits can be something on legal size. So I don't think that has any bearing, no. I created my own letterhead. I think I've sent copies of it off to people where people have to start understanding the administrative role that you have now over your legal person. And that's what that triangle that I was drawing there before with people was a very, very dumbed down, simplified version, just trying to get people to understand the concept. It wasn't meant to be like a rule of law. Like, no, this is it right here if you're not doing this. Because I don't believe in that. And I've said that right on there, that substance vitiates form, right? Substance is the most important thing. So what you want to do is you want to draft your own letterhead now. So I've drafted my own letterhead with my legal person name at the top, and then underneath the name of the legal person, just like a corporation letterhead. Underneath that, I write, office of the director or office of the administrator. I write whatever my role or my title is, because my name is irrelevant.
Chief Executive Officer.
Yeah, executive officer. That's where that letter comes from. The meaning behind it. It's just establishing your title and your role. I don't believe that there's no standing in law. There's no law anywhere I've ever seen that says that if you don't have a certain dotted line in a certain place on a document that it renders it void. The substance of the document is what's important, and the substance makes the form. So form is irrelevant as long as because we have to remember laws were created originally so that even simple-minded people could understand what their rights were, and all you have to do is express something and express it to the best of your ability on a piece of paper and get your point across. And it's because it's the meaning, it's the intent. The intent is everything. If law has no intent, it's not a law. And the contract makes the law. So therefore, whatever your correspondence is makes the law between your parties. So as long as you express your intent and your purpose, then that is the form. So, but I firmly believe, though, that as an administrator, you may want to kind of, like have a little bit of professionalism to your forms. And especially when I'm contacting the government, another nice little thing I like to put in there is I like to put a big title underneath my my heading, where I've got Dean Christopher David Clifford in all capital letters to let them know this is coming from that legal person. That's who's contacting them, and that the actual individual contacting them is the administrator. So my title is right underneath that, and then I've got the contact address, and I put care of, just because I really don't know what they've never gotten back to me on what the Canada Post code is, whether it's a military designation, I don't care what it is. I put it in there. I just say you can contact me, care of this, and then directly under that I say this document is a matter of public record. I let the government know, or anybody that I'm dealing with to do with the government, that every correspondence between myself and them is a matter of public record. It's now registered at that point, because that's what that's all registration is a public recording. So now I have a spot underneath that where I put public record number, and that's where I put the sticky for the registered mail if I want to send it registered mail. So it's definitely a matter of public record now. I've heard all sorts of arguments. You know what? Actually, I'm going to leave it there, because there might be questions before I get off topic.
Okay, and I wanted to ask you, how exactly do you sign your name then?
You know what? I've changed that over the years, and I change it all the time. And I think the most recent one that I have now is I used to go off the theory that as above is below, and I used to put the same thing right below my signature that I had up top for the title. But now all I do is I put Dean C. Clifford spelled normally, and then I put duly authorized administrator right underneath that, and that's all I put there. And that's all.
So you don't put all rights reserved or.
Nope. Because you got to remember, government can only interact with the legal person. They cannot distinguish between the man and the legal person. That doesn't mean you're one and the same, though. It means you're a part of the legal person. So you can assume any role, any capacity underneath that legal person, but all they can deal with is that agent in commerce. So I can't remember where I was going with that.
Well, I was asking you, how would you sign your document?
Yeah, so I just sign as the duly authorized administrator, right? My role is administration. I'm duly authorized to settle matters both publicly and privately. I'm the man. When you want to talk to this legal person, I'm the man. You don't talk to anybody else. And that's what that signature denotes.
Okay.
Yeah.
I have a whole series of... We have like 10 people in line with their hand up wanting to ask you questions.
Oh, I can actually say it's actually almost pointless to put all rights reserved. Simply because you can, but the only rights you can reserve with the government are the rights of the legal person, because they're never coming after the man anyways. It's not a human rights issue. It's a contract issue.
Yeah, but it's the man they take when they want to put you in jail.
Of course, because you're liable for whatever contracts you enter into. Right? You're the security. The same way that, say, the Attorney General where I live is a man by the name of Andrew Swan, right? He acts in the capacity of the Attorney General. But if he acts in that role, if he breaks the law that the Attorney General is supposed to follow, that fiction, he's the one that's liable because he was the one that was playing the role, playing the function. If you're the chess piece that moves improperly, you're the one that will be penalized.
You say on one of your videos that you know who the players are.
Know who the players are. There you go. That's a maxim of law. You ought to know with whom you deal. So my first correspondence with people is I want them to clarify precisely who they are. And I put that right in there. You ought to know with whom you deal. I'm not talking to you unless you tell me precisely who you are and what your standing is with me. What do I care? Like, what's your standing? What business arrangement do we have? Who are you?
Right, I've already used some of your stuff. I've put it into practice. We'll see how it turns out. Do you want to go ahead and start taking questions now? Or?
Yeah, absolutely.
All righty. We have Central Arkansas. Go ahead. Did you have a question for Dean Clifford? Central Arkansas, unmute yourself. I've unmuted you on this end. Do you have a question? Central Arkansas, did you step away from the phone? Okay, we're going to move on. I'll leave you unmuted. Just pipe in after we ask the next question. Dance Forever. Let me unmute you. Okay. Did you have a question for Dean Clifford?
Well, I'm
Go
not
ahead,
ready
Dan.
yet.
Oh, you're not ready?
Not ready. I want to hear more.
Okay.
I want to hear more. I have questions, but I'm not ready to ask questions yet.
Yeah, it might get answered by the end of it here. Who knows?
Yes.
Okay. All righty. I tell you what, you and Central Arkansas, when you get it together, and just go ahead and hit star 8 again, and I'll see you, and I'll let you go ahead and ask the question when you're ready. Okay, moving right along, we have guest 16. Go ahead. Did you have a question for Dean Clifford? Guest 16. I know there's a little bit of a delay sometimes.
Yeah, I noticed that when I was on my phone and the computer at the same time. There was about a 3-second delay.
Yeah. Guest 16, did you have a question? Yay or nay? Hey, you don't know how to unmute yourself from your phone. I mean, if you have a mute button on your phone, be sure to unmute it. I do that all the time myself. Sit here and talk to myself. And someone will come on and go, hey, is anybody there? All right, guest 16, I'm sorry, I'm going to mute you back out. Press star 8 if you'd like to ask a question. We're going to move right along to Anna, 88 Bell. Go ahead.
No question at this time.
Okay,
Oh,
thank
no worries.
you.
I guess everybody wants to hear it talk, I guess.
Well, you to mute yourself out, you press star 6, and to ask a question, you press star 8. And sometimes folks get it mixed up and do both.
Ah, okay.
Okay, but anyway, we have still 13 more questions to go here. Sunny Nguyen. Let me see here. I'm trying to unmute you. There you go. Go ahead, Sunny Nguyen. Did you have a question?
Oh, I guess there's a lot of things that are new to me, so I'm listening in.
Okay.
I'm also a Canadian and American, and all my families are Canadian. And I'm glad that I'm trying to tell this to my family in Canada, and they don't seem to understand it. So I'm really glad that there's a Canadian who know what they're doing.
Well, yeah, and you know what? It's recorded, so you'll be able to come back tomorrow or anytime or share the link with anyone to listen. So, but if you don't have a question, we're going to move on. Sunny?
Oh, no.
All right, well, thank you for coming on. Enjoy the call. Okay, we're going to move on. SF Guest 1. SF Guest 1, did you have a question? Oh, my goodness. SF Guest 1, if you have a mute button on your phone, try that.
Yeah, it's taking the pressure off me at least.
Giving you a little break here. Well, we've got 15 people lined up here. Just the list keeps growing. SF Guest 1, did you want to ask a question? Otherwise, I'm going to mute you out. Okay, if you want to ask a question, press star 8, and we'll get you right in there. Okay, Richard, North Carolina. I know yours is going to work. Hey, Richard.
Hey, how you doing, Angela?
Fine, thank you. Did you have a question for Dean Clifford?
Yeah, I do. But actually, it may have been answered already. From what you've been saying, it sounds like this would work with representatives of the federal government as well as in our country, the state governments as well. Would that be the case?
It would work with anything because this is all commerce and this is all contract. And once you understand that you're the one that created the legal person, it was your signature and or your parents in your stead because you're a ward of their ward at that point. It's your legal person. It's yours to operate in commerce. It's not bound by the government, but they want you to create this so they can interact with you. But anything beyond that, there has to be a contract for it. You have to contract with the government for everything. So it has to do with every branch of government. It doesn't matter what it is. There has to be a contract with you. But they operate on the presumption that there is a contract in place. And we don't know any better, so we never bring up that point.
Question then. For contracts like like an EIN number in the United States as an employer. That's a contract. But there was never full disclosure. Does that mitigate or nullify that contract because of fraud?
I actually, instead of it being like what do you normally refer that to? I actually refer to that as a tax exemption number when we apply for that. And what I've used it for in Canada is because I'm a contractor and I never did get a business number or a GST number, and I'll go to businesses sometimes and they'll say, do you have a GST number? So that you can give them a 9-digit number that waives the GST, the taxes. And I give them that 9-digit social insurance number that I have that I never use. Well, I never get a bill in the mail, ever. It's more of a tax waive number, like a tax exemption more than it is a contract to actually pay taxes with the government. I don't believe that one bit. I think that's just a presumption that we go along with when the government claims that. So you may want to clarify that with them, contact them in advance, like I tell people, and ask them to say, well, excuse me, every time I attach this number to my employment, does that make my income something that the government has jurisdiction over? Because to my best belief and knowledge, it doesn't.
Well,
and let them reply to that.
The thing about the EIN number is that's as me being an employer paying the taxes or paying into the fund for my employee.
Yep.
And apparently in U.S. law, you can't get rid of that damn thing.
No, you can't here either.
But it should be held void because it is an adhesion contract that full disclosure never was provided.
Yeah, but all you have to do is just not use it ever again.
Okay.
You can work without a social insurance number or an EIN down the States. You can open bank accounts without one. You can exist without one. I did that for a number of years when I first started battling Canada Revenue Agency. I disappeared completely. I didn't exist for about a period of 5 years before I came out of hiding and decided, no, I want to go after these bastards.
Yeah, I want to go after the bastards too.
So that would be some of the processes I explained then, where you contact them and say, hey, wait a minute. Just because I have this EIN number doesn't mean that the money I'm making is something that you have the jurisdiction to tax, because I wasn't performing a function of government. Are you claiming that the funds I made came from the public coffers? Can you prove that?
Well, mine kind of do, because they come from Medicaid, for example, or Medicare.
Okay, that might be a little bit different then. See, that's part of the problem. If you actually are working for the government, that's almost unknown territory.
Well, no, I don't work for them.
Yep.
I'm not an employee. I have a contract with Medicaid for the state of North Carolina, for example, and get reimbursement for patients that I see. Okay. But I'm not their employee.
Okay, you may want to try something like what they do up here in Canada. I think Paradigm Group was doing it, and they were filing zero owing returns then when you went to do. So they were doing the deductions all year just to not cause a problem with where their workplace was. But then they file a zero owing return where, well, no, none of the money was income. I didn't make, the legal person didn't make any taxable income. And then when they come back at you and say, well, how can that possibly be? Then you say, well, none of the money I made was performing a function of government through a contract with the government.
That's right.
That's where you would do that. And so if need be, you would go to court and you would fight that, and you'll only win that one once. I think even, and you guys got case law now down there because of Joe Bannister. I fought the IRS and I won.
Okay, yeah, that makes sense.
Yeah, that might be the way to deal with that, and that's how to deal with things administratively.
Can you repeat the name of that group up in Canada that does that, though, so I can reference that?
Yeah, their name was Paradigm Group. That was Russ Perisky that was doing that, and I know one of the educators there. And but that's all they were doing was they were filing zero owing returns. But then I think they were losing some of their court battles. Then when they had to go back and then explain why they were filing zero owing returns, and that's because they weren't making the proper arguments at that point.
I gotcha.
Yeah.
Okay. Great. Thank you very much.
Oh, you're welcome. Hello.
Hello.
Oh, I'm sorry. Cherry Stone, go ahead. Did you have a question?
Yes. Hi. Hi, Dean.
How you doing?
Hi.
Pretty good. Here's my question. A situation, I have a court date coming up on Monday. I just recently heard about you, and I'm very excited, to see if I can try this in court. The situation is it's the Homeowners Association. They had already gotten a default judgment and a lien, but now they have they're trying to subpoena me to come to court to bring, like, my bank account, a bunch of other crap.
Yep.
And also to answer interrogatories. So my question to you, Dean, how can I use this information in order to get out of this at court?
Okay, so they've already got a judgment against you?
Uh-huh.
Okay, so what you have to go do then is you have to go back and you have to start attacking that right from the beginning again. And that's when you go back, and this would be the county, I guess, probably for property taxes?
Yep. Uh-huh.
Okay, and now would be the time where you start contacting the county and go right back to square one regarding their judgment, because you got to remember, it's never too late to go back and to void a fraud. It's never too late to go back and void a fraud. So you want to attack the very start of this proceeding to get rid of everything that went on, and that's to contact the county and ask them what their standing is with your property. You can just say, it's just come to my attention, and it's now my understanding that I own my property fee simple as defined in Black's Law Dictionary, which means absolute. I'm the absolute owner of my property. Say my property is not used for any function of government. Because what happens is government actually claims to be a joint tenant in common with your property. And I don't like to get into, I'm just going to look up fee simple real quick while we're talking. A lot of people try to get into this argument with me where, no, you see, because it all goes back to the Vatican, and the Vatican holds title to everything, and these papal bulls, this and that and everything else. And they're not relevant arguments because that's completely unprovable. I really don't think that's what's going on. I think it's all contract law where the state, the county, wherever you live, they are claiming to be joint tenant in common on your property. The problem is they didn't help you buy it, did they?
No. And let me just clarify this. I'm sorry, Dean. Go ahead.
No, you go ahead.
I just wanted to clarify. It's actually out here in the States, in some of our subdivisions, they have homeowners association.
Yep.
It's basically, in order to buy a house in that quote-unquote subdivision, you are forced to be part of this homeowners association. Right.
Okay, and then you have fees that you have to pay to be part of that?
Uh-huh. Yep.
And what does this homeowners association do for you? What services does it provide in exchange for this money?
The services I guess they provide is like if it snows, they do the common area. They don't do anything on my property. But, if it snows, they plow the common area, or they'll do trash pickup. So they do provide some services.
Okay, but those are all services that the state's supposed to provide from state revenue. So I don't understand where this homeowners association would come in. It sounds to me like it's somebody that's trying to subvert something that the state's supposed to be doing, or the county, and then charging you a fee to do something that the state already collects public revenue for.
That's absolutely right.
So I would attack that, because road clearing and anything to do with that stuff, that's all paid for with gasoline taxes, right? That's an apportioned tax. They can't just, I don't think that has any standing. You could easily attack that and ask them, well, where, what services do you provide for this money? Because everything has to be an apportioned tax, and just start asking questions and the whole legitimacy of it. Just because I signed up for this homeowners association, how does that automatically bind me to these fees and these payments for services that the state are supposed to be providing? Otherwise, I want all my money back from the state. Why am I paying taxes to them every time I buy something if you people are just going to charge me for what the state's already charging me for? So it sounds like some fraud's going on there, and if you were to start to bring that up in court and demand some answers, you might see some action on that.
Okay, so how do I present myself in court?
I'm not sure.
Dress like a nun.
Yeah.
Nice. You are crazy.
Hey, you know what? You want to be respected when you walk in there. You want to look like a schlub,
Yeah, I mean, usually when if you mean like how do you say who you are when you're walking into court?
Right.
I guess.
Like, do I say that I am the administrator? Do I say I'm from the office of the executrix?
You are absolutely the administrator, and here's the thing too. So if there's taxes that are owing, this is something that can be discharged. So that is all correct. You can discharge all these taxes just by your signature. I talk about this on a lot of other videos about the AFV thing is only correct not because of anything to do with the accepted for value. It's just your signature. Your signature alone is value because you're the creditor of the United States, right? If the United States can use your signature to create money, then you can use your signature to create money. And that's all discharging debt is. It's not coming out of some magic fund somewhere or anything. You're just discharging obligations, right? So you're actually going to be bringing down the debt of the nation when you do this. So when you walk into court, and especially with this homeowners association, when you contact them, or if you're going to go to court, when I stand up in court and I say, I'm here regarding this matter, because you'll notice they always want you to speak to a matter. They don't want you to show up and say, yeah, hi, I'm Dean. You say, well, I'm here to speak to that matter. And when they say, well, who are you? You say, well, I'm the duly authorized administrator for that legal person. They know damn well it's a legal person. And you say, I'm the duly authorized administrator, and I'm authorized to settle matters both publicly and privately. So I want you to present me with your original charges right now so I can settle them. And if they refuse, then you say, well, obviously they're not my charges if you're refusing them to give them to me, because I'm the only one authorized to settle them. You're supposed to be holding them in trust for when the administrator shows up for me to settle by my signature. If they refuse to give it to you, you say, okay, well, obviously you don't have any charges for me, so I'm leaving.
And then walk my ass right out of there.
Walk your ass right out of there.
Okay, so when I am asking them to give me the, I'll say the instrument, so I can discharge it, so I can sign it with my signature, what am I putting on this?
What I would do, and this is actually a lot of this information is stuff that we haven't shared with anybody out here, but you can just write accepted on it, right?
Okay.
A lot of things accepted and then sign it, and you want to sign above whatever other signature is on there, because if they've got a charge for you, that means it's already been signed by somebody from the government or some other individual, right? So that's why you want the original document that the judge has that he's holding for you, for the administrator to show up to settle the matter. If you tell them that you're the duly authorized administrator and I'm here to settle that, they have to give that to you. Because what happens is when people are just accepting things for value and accepting remittances, and they're not accepting them both publicly and privately. They're only accepting in the private. And then the government basically is assuming the role of the public administrator for your estate, for your trust, and they're saying no. But if you sidestep the government altogether and say no, I'm the only duly authorized administrator. I can accept both privately and publicly. I'm here to settle that matter. Give me your original issue orders, or give me your charges. Give me whatever commercial paper you have, and I will settle it right now. And they're going to know exactly what that means. And if you get really good at it and you really want to start arguing, and they say, well, no, you can't have that charge, and you want to say, well, then it's not my charge, and you get into an argument, then you say, well, if it's not my charge, I'm leaving. If it is my charge, give it to me. If you're not going to give it to me, then you're concealing pertinent documents. You're denying me due process and remedy. This is whatchamacallit, it is an abusive process, I guess, really, as well, but you can start throwing all sorts of terms around. They're not going to like you. They're probably going to have some sheriffs called in, and people got to remember that, by the way. A lot of the times when I send people into court and tell them to do this stuff, I'll warn them. I'll say, when you say a few of these things, they're probably going to have the sheriffs come in.
Right.
Right. So you got to be prepared for that, and you got to stand. You got to stand your ground.
And I also have to say, I do not consent.
Don't touch me.
Don't touch me.
Don't touch me. Stand down. Public servant, stand down. Don't touch me.
Thank you so much for your help, Dean. I really appreciate it.
I'm not going to guarantee they're not going to touch you, by the way. That's my disclaimer on that. But we're doing things right when we do this. And what we're doing is if they have to go to the extent of now continuing to physically harm you and arrest you to get you to comply, we're just exposing the fraud that they're carrying out.
And that's under duress.
And it is under duress, yeah. And you know to say some of those things, too, so.
Right. So it's documents that they're trying to subpoena from me. It's probably best if I just don't even bring them, because should I file anything in the case?
Yeah, like what are they trying to subpoena you to bring?
Oh, just bank statements, any bank statements.
Oh, I'm sorry, I don't have any of those. I'm sorry, are you forcing me to testify against myself?
Yes, a credit report. It's ridiculous. I've never seen anything like this before.
Yeah, say no, thank you. I'm not. Nothing can compel me to testify against myself. Nothing on this planet can compel me to testify against myself. That's a violation of your rights.
Okay, so do I need to file anything in the case, like any kind of affidavit or anything?
Yeah, I would send them in just a quick little letter saying I will bring nothing of the sort because I refuse to testify against myself.
I love it. Dean, I am going to give you an update to let you know what happens.
Well, hey, yeah, let me know let me know what happens with that. Like I say, I always like to know because you never know what kind of results you're going to get. They really don't like this civil disobedience.
I know, but I've been a rebel rouser for a while, so my eyes have been open. I can't turn back now. Yeah. Thank you so much, Dean. I appreciate your help.
Hey, you're welcome. I hope it helps.
Yeah, I'm sure it will.
I'm sure.
Thanks, Angela.
Thank you. Okay, next in line, Shupek.
Hi, Cynthia, Maryland. I've been watching your videos, of course, for about a week now, and I'm glad to say that you're one of the few that actually grasps this credit concept, and I really appreciate that because not enough do. But my question is, you've not mentioned yet anything regarding claiming your land or yourself as your land in the process, either quit deed or torrents or anything like that, and just wanted to get your perspective on it.
Okay, my opinion on all this, and I've had somebody send me information on Crown land patents in Canada where you can apply to the Crown here and they'll send you a Crown land patent where the Crown recognizes your claim to this property forever. And my only argument to that is, well, that's all fine and dandy, but exactly who are they to grant me anything, right? Mm-hmm. Where did they get the land from? So I'm a real big fan of not doing any of that kind of stuff. And I think that there was a wonderful thing a couple of years ago that came out, an article to do with meets and bounds. Mm-hmm. And getting the meets and the bounds of your property established, and then basically sending a letter to the government, a notice to them that you are making claim to that property.
Okay.
Period. And as far as you're concerned, you own it, and I looked it up here because of that last caller, fee simple absolute. I'm claiming to own this property, fee simple absolute, and you're just you own all the equity in the property because nobody can own the land, right? And that just goes right back to the created is owned by the creator, right? So we all know who created the earth and the land and everything that's on it. We can never own it, ever, but we can have an equitable interest in property. So you set your meets and bounds, and I don't care if you want to use GPS coordinates and the four corners enclosure of your property. You send that into the government. You say, I'm claiming that I owe this fee simple absolute. I don't need any friggin' land patents. Because for me to apply for a land patent, that would be acknowledging that you have the authority to issue such a document in the first place. And I claim that you don't. If you're claiming to have the authority to issue such a document, where does that authority come from? Because if you're going to pull out some papal bull from the 1400s where some asshole at the Vatican made a decree that he owns the planet, well, shit, let's go to court, buddy. I want you to bring that argument up. We'll see who's going to the psych ward when you say that.
What I was referencing is the birth certificate, meaning your physical,
your physical
body versus land.
Same thing. It's the same thing. Who created your body?
How do you do meets and bounds on a physical
just look
man
that up.
Or woman?
Look up meets and bounds. So I started answering there before you even done asking your question. That's great. Okay, you can look up meets and bounds online, and it'll tell you exactly what meets and bounds are. And then you can use that to establish your jurisdiction over your own property. But, now finish your question, and then I'll answer it.
Well, that covers it for me.
Oh, okay. Well, your body's the same thing, by the way. If you want to describe what does the birth certificate describe? Baby girl, 8 pounds, 2 ounces, blue eyes, blonde hair. They take a stamp of your feet. Your landmarks, the bottom of your feet, your landmarks. That's your meets and bounds, and that's in the birth certificate, right? So that registers an event that has happened. Well, have you ever contacted them since you were the age of 18 and said, yeah, by the way, I'm this 100-and-something pound whatever, blah, 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 this and that, and my body's my own, just so you're aware. You set your meets and your bounds, and you tell them this is your body because God gave it to you. He created it. Ultimately, he owns it because believe me, one day he's going to call it back and you're going to die, and that's going to be the end of it. So contact the government and establish these things. Just say this body you guys keep arresting and throwing in jail or whatever you plan on doing into the future, well, it's mine because I live here.
All right. Is that
if
good
that has
for
any
you?
relevance.
Yeah, it's perfect.
Oh, okay.
All right, great.
Great.
Okay, next, let's see. We have California. Go ahead, California. California. Is that Craig in California? Hello. Did you want to ask a question? Who is it?
Joel in California.
Okay, go ahead, Joel. Did you have a question for Dean?
Yeah, he's pretty much been answering them, though. But, Dean, how has all of this new contracting helped you out with your own construction business? And, instead of just, arguing about the taxes with the government, I'm sure it's been able to help you out with just contracting in general with the other public and other private citizens in your contracting business.
I would have to say it was actually the opposite. I think it was my comprehension of contract law from construction that helped me deconstruct what's going on with the legal person. And since I really kicked this into high gear last year, my construction company has suffered horrendously as I spend 16 hours a day doing this stuff now with almost no money coming in because it's just become an all-consuming passion. Right?
Well, but basically because you're just lacking time towards your business because you're focusing it on this.
Yeah, and even interest. I got to tell you, I get fired up about this. I don't know if it's the mass awakening that's going on around the planet or what's going on, but I get right fired up about this stuff, and that's why some of the interviews I get talking with people there, I'll just get swearing and just get right worked up about things, and I do the same thing in the courtroom too, right? You got to understand, a belligerent claimant is going to have his claim heard more so than anybody else. And so my contract experience from contracting is actually what helped me break down what's going on with the person.
I see.
Yeah, I at some point here I got to start picking my work back up here and getting that kind of part of my life back on order. But in the meantime, I'm kind of going with the momentum that's taken over here since putting a couple of these little private lessons online. Like I hope everybody understands, we weren't expecting any of this. We had I got tired of there being no action where I live. Nobody was doing anything. Nobody was learning. No one was doing their own research. So I decided, well, I'm going to grab this group of Freeman guys here in Winnipeg, and I'm going to start teaching them some stuff to see what happens. We recorded our first class. Somebody put it online, and here we are, like 5-6 weeks later, talking with people on the internet because we got like 87,000 combined views on the internet now. It's just been ridiculous.
Do you know who sent me the link to your video? Do you know Robert Fox?
No.
You don't know Robert Fox? Oh, he's a legend here in the United States.
Oh, okay.
That would be flattering to me. But anyway, I can relate to what you're saying, though, because it's an obsession. It becomes an outright obsession. I've been doing it for 10 years, and it doesn't stop.
No, it doesn't. You could never
it's
go
like
back
you're cramming for some great test that's going to be given at the end. I always say that.
Yeah, you couldn't go back to living the life of a slave even if you were forced to. They'd actually have to kill you because you'd always feel like you were just being put back in a cage. Right. So, and I think that's even more important than really cracking the code of what's going on. Really, people just have to wake up and realize that at some point here we just got to leave the government behind and just discard them because they're not relevant
anymore. Take responsibility
for ourselves.
For yourself.
Start creating our own communities and our own infrastructure and our own businesses, and just leave these people. Everybody, one of the things I wanted to talk about in one of the upcoming videos, I think, is that everybody wants this solution that they think is going to give them this unlimited checkbook where they can just go out and buy all these fancy cars and mansions, and they got all these billions of dollars in these secret accounts the government's keeping. No, that's all nonsense. When you really understand what's going on, you'll know enough to realize that it's not your game. It was created to suck you in and suck you dry. It wasn't created to give you everything you're ever going to need in life.
Are you familiar with the Amish people?
Yes.
They have a real good method. They have a thing called shunning.
Yeah, there you go.
I'm trying to create a new what is it? What do you call it? Sound bite. Where the federal government is no longer relevant. I repeat it often, and we have to create our own sound bites. All the masses out there speaking sound bites. We have to create our own sound bites. Sort of drum it into them, things to make them think.
Yeah. Well, the thing is, the government needs us because where it sits right now, because they're broke and they're bankrupt and they exist on fiat currency, and we are the creditors of the nation. This is really relevant for you guys all down the States, is what a lot of people, Americans, don't realize, is when the government talks about how much money they owe. The federal government owes all this money, and they try to convince the American people they owe all this money. No. The American government owes all that money, and they owe it to you.
That's right.
You're the creditor of the American government, not the Chinese. Nobody else on this planet. It's a retarded topic they try to bring up that, oh, look at all this money we owe the Chinese. No. The American government owes everything to the American people. That debt is owed to you guys.
Yeah.
So I raised that point recently in Canada, too, where I said, well, how hard is it to go into a courtroom and if you're up against CRA in Canada? In the United States, it would be the IRS. If you're up against the IRS and you just raise the point just saying, well, hey, all this money that the American government owes that you're claiming to collect taxes to pay off, do they not owe it to the people? And if they owe it to the people, then why are you trying to collect off me? I am the people. Why are you collecting off me to pay me? I don't think the IRS's case is going to go too much further against you.
Okay, California, is that good for you?
It's good for me.
Yeah.
All right.
I know accepted for value definitely works. I've been able to discharge all my taxes, no problem.
Yeah, just once or multiple times?
I've had multiple accounts. I did some basic A for Vs with several other accounts, but the ones that just never, ever bothered me ever again was the federal taxes and state taxes. But
yes,
on some of the private corporations, they sent back my A for Vs saying they don't accept this type of payment.
Yeah.
But they knew to send it right back, because if they had kept it, then
offer an acceptance.
Then they accepted it. But that was very interesting to me on how that worked, and I felt a sense of relief. I said, "Oh, okay, so the government completely understands this."
Yes,
so
well,
it's just a matter
of with a private corporation, that's a little bit different. But with the government, you can discharge any obligations against them. That's why the AFV works for them, and the signature is really all you need. You just have to write accepted on it. But if accepted for value works, great. We have a much tougher time in Canada. The government doesn't do anything. They send everything back, or they ignore it altogether. They keep it. They don't credit any accounts. Keep coming after people in the courts. It's brutal up here. You guys have it a lot easier than we do. With the private corporations, you may want to try sending them a promissory note instead of just AFVing a bill. You might want to try sending them a promissory note, because that's something they can convert to cash through the bank.
No, that's interesting. Yeah, I was just testing to see what would happen, and tried it with some of the utility bills. But I just found out how interesting it was that they knew to send it back.
Oh yeah.
Because if you accepted it, they were going to keep it, but they send it back just as quick as I send it to them.
Yeah,
and it
like
was registered mail.
within 72 hours. Sure.
Yeah, well, as soon as they received it, they had called me and sent it back, and very nicely said, "We don't accept this form of payment. Please send a different form. What we do accept is," and then they asked what they wanted. They wanted cash, check, or something else, but they were playing the game, to the T.
Well, this is simple then. You can look up the definition of cash, and by law, and you'll be able to find it in the American law books, because they're bankrupt. A promise to pay is cash.
Yeah, and send it back to them, and then they'll have to discharge it.
So send in that definition, and I'm sure you could probably find some court sites down there as well about how promise to pay is payment. That is cash. Send them those definitions and send them a promissory note and say, at your request, here's your cash.
Yeah. Yeah, that's
if you want to go
great.
If you want to go to court and contest that this is cash, be my guest.
Yeah. I didn't take it that far. I was in test mode and just see what happened. And I just wanted to see if it was going to be accepted or not. Then I went ahead and sent the payment. But, you've got to test this stuff out for yourself to make, so that you can see for yourself. Just listening to YouTube videos, you don't want to go off of that. But when you see what works and what doesn't, then you actually know, because you've experienced it.
Yeah.
Firsthand knowledge. So it's very interesting, and it's definitely true, and it's definitely working for me. So,
that's
I thank you,
to
and I
hear.
appreciate it.
All right, we've got 20 people in line. Let's go.
We'll try to go quicker with these then.
Is that it for you, California?
Yes, it is. Thank you very much.
Thank you.
I won't go off on any more tangents. We'll just keep the
it's all right.
answers here.
We'll stay on as long as you like.
I'm not going anywhere.
All right, let's go ahead to Alpha 99. Go ahead. Did you have a question for Dean Clifford?
Yeah, Dean, how you doing?
Not too bad. Yourself?
Good. I did listen to your tutorials and whatnot a couple of weeks ago now. And in one of them, you mentioned you were talking about your brother going to court.
Yeah, I like to use his as an example all the time, and he might even be listening tonight. So. Well,
that's good. Hi to your brother. I have a similar issue. I have a family matter, and what happened is I didn't attend the first court appearance, so custody was handed to my ex-wife. Also, certain legal determinations were made, and there's a number of things that layer onto that. But what I want to ask you, the question I want to ask you is, how do I go back and revisit that to, with the knowledge that I have now? I mean, I've been picking up a lot of information from everywhere. I listen to Ucadia regularly, and of course I went through all your stuff. I don't know what your brother's circumstances, I don't know if he caught it on the first court appearance, but there already has been an order, there's some maintenance issues and stuff, and what's your answer to that?
Okay, now by first hearing, you mean it was just like it was the initial hearing period, first time you'd even been...
Well, it was, and I never attended.
Okay, I would say you should have no problem going back and fixing that. I mean, one of the things that we did with, except my brother actually did show up for the first hearing, just to say that he had just received the claim being made against him.
Uh-huh.
And he hadn't had time to review it yet, which he hadn't. It had only been like 7 days. He just got served 7 days beforehand. So, and it was one of those situations where the judge started yelling at him and saying, "No, I'm going to remand for 3 weeks, but when we get back here, you're going to do this, you're going to do that, you're going for a blood test, you're going to pay for it." And the judge was already just being a bit of a dick to him. And so he told me all about it, and he told the judge, he goes, "Well, I need time to get my counterclaim together." And the judge said, "This is family court. You don't file counterclaims here, and you do whatever I tell you to do," kind of stuff. So that was when I generated the document that we called I've got it right here in front of me. It was a sec here. I've got that. Yeah, I do have it right here. Okay. It was an interesting one. I wanted to see what would happen with it. So we filed this into the court, and it was an affidavit. And it was a notice of injury, notice of fraud and conversion, and then unlawful. That's the most recent one. My bad. It was a notice of injury. It was an affidavit, and it was a motion to quash. That's what it was. So what he did in the affidavit, though, and it was about a 20-point affidavit, was he removed any presumption of consent for the state to arbitrate in a private dispute.
Absolutely. That's the area that I'm going on.
Precisely.
And that's what I assumed happened, in the case. But I know that you can always go back, and I know that if you're claiming to be, the executor, the occupant of executor of your own estate,
administrator, whatever you want.
Administrator. If you're claiming that, then the jurisdiction is basically pulled right out from the whole situation. What I want to do is prepare an affidavit inclusive of everything imaginable in the affidavit.
Well, keep it to the point, though. Don't see people want to go overboard with affidavit. You want to keep it to the point, and you just want to go to the extent that you've made it quite clear that you're removing consent to independent arbitration from the court. Say say that this is a private dispute that can be settled privately. There's been no attempt by the other party to even try to negotiate this matter, right? And going straight to court is tax fraud if the two parties have not tried to exhaust their administrative remedies.
Yeah.
So
I got one more. I got one more layer to this. I sent like you too, I went through the whole Nui Core and so forth. I went through that process of learning and so forth and common law and whatnot. And I prepared a notice of understanding and intent and claim of right, and I sent it to my ex-wife.
Yep.
And I sent my understanding of everything all listed out. I also sent a notice extension, and I also finally sent the notice of default that she didn't respond to.
Great.
Now, why can't that document be used in court?
It can be. What you have to do is when you're going to go to court, you're going to want to put filings into the court now. So you're going to want to file some motions before the court, and then
Right.
So along with your affidavit saying that me and my ex-wife, whoever she is, we already have an existing agreement. I'm not allowing this court to interfere in that agreement. This is the agreement, Exhibit A, and then you add that NUICOR, that claim of understanding, whatever the document you're talking about, you add that as an exhibit to your filing that is also going to be a motion to quash the previous court order.
Right.
And you don't have the authority to do that because I've already...
Well, I actually had that in the notice of understanding. I said the previous legal determination was agreed upon to not, you know what I mean? It's always all in there.
Yep.
She just didn't respond, and I did it registered mail.
Exactly, and the registered mail filings, the notice of default, whatever you sent should all be separate exhibits in your affidavit when you outline it and say, I gave her X amount of time to reply. She did not, and then, Exhibit B, your mailing filings, and then I issued a notice of default, Exhibit C, and then have it back from there in Exhibit C, and then go through, and then in your motion to quash the court order, right, you're going to want to say things like you're not granting the court the authority to arbitrate in a matter that's already been settled.
Or further, any further.
Not anything, and anything beyond
at
that.
all.
And then you basically are going to make a motion to dismiss all charges in the first place, or a motion to throw out the statement of claim.
Yeah. Okay.
The motion to strike the statement of claim from the court file because there is no claim. You already have an agreement. In fact, she's the one violating it, and you're thinking about taking her to civil court if she doesn't obey the terms.
Yeah, that was there was nothing there. Basically, in my notice of understanding, it was me being able to see the kids on a regular basis, which she's denying me access. I've gotten court orders. She just takes them out of town and stuff. And the long and short of it is she's not listening to anything. But I with this document that I felt I did a pretty good job on. Yeah. I think I sent it to you guys, your site there in Manitoba, just to look at. But
possibly.
Nonetheless,
but that's what you want to do is you got to put the affidavit. You got to remember, anytime you're putting a filing into a court, and this is probably relevant for a lot of people that are going to be listening right now, is there's three things that are very, very necessary in any filing you put into the court. I don't care how you phrase it or file it. There's got to be a plain statement of facts.
Yeah.
And then there's got to be damages based on that plain statement of facts. And then there's got to be the remedy you're requesting to fix the damages. If whatever you're filing in the court doesn't have those three items, you might as well file nothing.
Yeah.
Right.
Do you not have to annex these documents to court files?
Annex them? I'm not sure what that means.
Okay. Yeah. I mean, attach them to court files.
In
order to get the vehicle.
There could be a court file open if you're in court.
No, there is a court file, but sometimes these things have a habit of being lost or not being entered. Your court clerk.
No. You go right down to the clerk of the court, and you give them, him, her, whatever, your affidavit with your motions to quash for the existing judgments, and then to dismiss whatever claim is before the court with your affidavits all filed.
Clear the controversy.
Yeah, basically. But they're going to file that in the court, and then a judge is going to hear it. Actually, a judge is going to look at that before your next hearing, even. And then put whatever you want so that you don't have to even speak in court the next time you get there. The only thing you have to say is, well, did you not read my affidavit?
Exactly. That's what
what didn't you understand about the affidavit?
Right.
Right? I'm not...
Okay, I think that's sort of what I expected to hear because I'm sort of been coming to that conclusion on my own. And that's sort of one of the things that you said in your, this is for everybody, one of the things is we have to learn these things ourselves progressively, and we help one another by having these conversations, by having these tutorials, by people willing to sacrifice their time and putting these presentations together, which I thank you for. And we have to learn it on our own. If we don't, we're not going to be competent enough to follow it through. And I appreciate what you just the information you gave me. Thank you.
Oh, you're welcome, and you bet.
I live in BC.
I would be competent people. So
there was another thing I was going to say. I live in BC, and we were going to go through Winnipeg. How do we pop in and see you guys? Go and enter a meeting there.
Try to leave a message on freemanitoba.com there.
Yeah.
And somebody on that site will always get it. One of the administrators of the site or something like that always replies to emails and stuff there. So.
Okay.
It's not a problem. And then finding out where we are in Winnipeg, we're not secretive, believe me. I mean, I'd even like it if police showed up here to come to a meeting so they could learn their human rights too.
Yeah, right. Yeah, me too. I got another issue. That's why I was about a police brutality issue with me, and I'm working on. So I was going to ask some questions on that, but we'll save that and let the other callers get a turn.
Yeah, you'll be able to figure it out. No worries. Keep on.
Yeah. Okay. Thank you very much, Dean.
All right. Have a good night.
Okay. Bye.
Thank you. Okay, we're going to move on. Let's see here. Northeast California. Go ahead, Northeast California.
Yes. Hello, Dean. How are you?
Not too bad. How are you doing?
Pretty good, thank you. I hate to sound like James Timothy Turner here, but who do we see to get paid for damages that have been incurred?
Like, for instance, a violation of a fee schedule or just human rights abuses, that kind of stuff?
Just damages in general. You know, when you go in there into their arena and they damage you.
Yep. You're going to want to the process that I like to use, and I'm still not even done my the ones that I'm bringing before the province right now here where I live, is when you've been damaged. I'm not sure the names of the courts down the States. Whatever ones where you take a lawsuit where you've got an injured party that's actually making a statement of claim and filing in the court. I'm not sure. Is that the county court, or how does that work down the States? District court. I don't know how that all works.
Say that again, Dean.
Wherever you sue somebody.
Okay. District court? Yeah.
Probably the district court then, yeah. And so you're going to want to get a lawsuit together. And you're going to want to learn the rules of the court. And I keep you're rarely going to be able to use a lawyer to do this, because you got to remember a lawyer has a superseding oath to the courts and to the people and to the bar association.
To the Queen.
And to all these superseding organizations. So you're going to want to learn how to file your own lawsuit. And you're not going to want to file a lawsuit until you've already won your case. And that's just Winston Shrout 101. Don't go to court until you've already won. And the best way to win before you even get there is a perfected commercial lien. You're going to want to get a perfected commercial lien against whoever's damaged you, which is private remedy. And then you're going to want to take your private remedy into the public as an exhibit in your public filing that you're going to be doing in county court, which is a lawsuit. And they probably have rules and forms you got to fill out, because it just makes sense. There's got to be some order in the way that lawsuits are brought before a county court for a judge to look at. And you're going to want to learn some procedure and stuff like that to go into the courts and enforce it. Unfortunately, that's about the only way you're going to get remedy. I have yet to see somebody who is actually collected on a commercial lien with a UCC filing backing it. I have yet to hear of anybody ever getting a check, ever. And until I do, I'm going to say that the only way you can do that is to get a perfected commercial claim, which is private, and then bring it into the public through the courts.
Okay. What about arresting their bonds, public servants' bonds?
Well, I mean, I've done all that stuff. I filed PPSA liens against government here. I've done all sorts of stuff, and you can arrest the bond, but then where do you go with that? Right? I've heard of people trying to discount these liens and debts to bankers and all sorts of information out there, but okay, you go in and you arrest the bond, but then nothing happens.
Okay, I mean their E&O, the errors and omissions insurance, when they've damaged you, that insurance company should pay you, right?
They should.
That how it goes? Okay.
They should, right. But again, you got to realize sometimes the insurance company might just say, nah, no, you need a court order.
Yeah, or they'll say sue me.
Yep, sue me. The
insurance company.
They don't care. They know that you're not gonna be able to do anything about it, right? The insurance companies know that 99% of people are going to go away before they have to go the full length of suing in court and getting a court order which they have to obey.
Right. Well, most people accept no for an answer. That's what the deal is.
That too, yeah.
So now, in these cases, they're creating these bonds and stuff. They're getting paid on these cases. They're the debtors. We're the creditors. Actually, we should be getting paid on these cases. Is that correct?
Are you talking like for, say, criminal charges now?
Yes.
Yes, absolutely. We're the ones that are supposed to be getting paid for that. I got a big, long theory I could get into that I'm not going to. But, yeah, there's no question that because even if people are like AFVing these criminal charges in the courts, like I know people have been doing, right, they get the AFV, the criminal charge, and it sometimes goes away, the state is still collecting on that money. They're still cashing in that charge, that criminal charge. And I think that's where the duly authorized starts to come in, where when you duly accept and duly endorse a criminal charge, and this is something recently that even somebody else has kind of put me onto, and then just sign it with nothing surrounding your signature so that it has nothing attached to it. It's just freely on the document. You should be able to collect on that ticket. You should be able to basically take that ticket and go to the clerk and say, cut me a check.
Okay. But you probably, I guess you haven't never heard of anybody doing that yet.
I'm actually doing one right now where I've got the city where I live is actually dumb enough to have issued me another bylaw violation pink ticket. They didn't give me the original, the white one, so apparently they weren't they don't know that I'm the administrator. But all I did was I wrote new original on the top of the ticket. I duly endorsed it, duly accepted it. I signed above their signature, because you got to remember this document has their signature on it. So now I've got a two-party document that's got a due date, an amount due. It's got everything that makes up a bills of exchange, except it didn't have the amount. So I filled in the amount for what the city owes me from previous human rights violations, and I'm going to be going down there next week with this new bill, and I'm going to be demanding payment from the clerk. So I'll let you know how that goes.
Sounds good.
Yeah, we'll have another call. We'll do another call.
Okay. Now, what I was wondering, are they the administrators and we're the administrators too at the same time?
No. No.
Or are they strictly trustee / fiduciary? If
they are trying to administrate your estate, they are meddling in your estate, and they can only do that on the public. Right? If they're going to meddle in your estate, they're going to do it because you allowed them to on the public side. Because unless you give them notice that you're duly authorized in both the public and the private, and that you're the legitimate administrator of the estate, they're just going to handle things on the public side for you, and you're not going to like the way they do it.
Okay.
Right? So if they ever try to do stuff like that, you say, no, hey, whoa, no, you're not authorized to administrate. Even on the public side, I'm the only one authorized to do that. Are you meddling in my estate? And they're going to say no right away.
Okay. Now, what is your take on appointing someone else as the administrator, or say someone is timid to go into court?
Oh, yeah. If you know somebody that's competent that can do this stuff, and you want to appoint them as the administrator of your legal person, your estate, your trust, whatever you want to call it, by all means. I'm the administrator for 7 people right now.
Okay. Now, can you and they should be able to appoint as many as they want. It's always good to have at least two witnesses.
Yes. If you're in court, yeah, it's always best to take witnesses with you because they like to change the transcripts.
The way I look at it is they change players on us all the time, so why don't we just switch players around like they do on us?
I don't think it serves them any benefit by doing that. I think they're just trying to hide people so that they think it's confusing us, so we got to go after all these different people. I don't. When I file a lawsuit against where you are, it would be the state. You got to remember, every action done by an agent of the state is an act done by the state itself. It's the state that injured you, not the individual. So you sue the estate and you just add numbers to it. Unknown number 1, unknown number 2. Or if you have a name, you add their name to it. That's great. That's just increasing damages. I don't think it's a good idea for you to continually change administrators. I don't think that's a very honorable thing to do.
Okay.
Yeah.
Well, I just got one more question. When you talk about demand to be presented with the original charges, how often will they present those original charges? Is that something that's going to be very hard to get?
No, you ask them. You say, "Excuse me, is the original charge not for the administrator? Are you not supposed to appoint that to the administrator?" And get them actually saying no on the record, because that's a complete friggin' lie.
Okay.
Right, and ask them that. And that's why, I did that like a year and a half ago, I think, in the court there once. I said, I want, show me the original charge. I was saying, show me the original charge. But we're not required to show that to you. I said, well, is it my charge? They said, yes, it's your charge. And I asked them 3 more times. I said, are you sure that's my charge? Yes, we're sure it's your charge. So you're saying it's definitely my charge? Yes, Mr. Clifford, it's your charge. I said, good, if it's mine, give it to me. No, we're not going to give it to you. I said, okay, well, it's not mine. I'm leaving. If you leave, we're going to order a warrant for you. It's like, well, isn't that kind of contradictory?
All right.
Right, so they get mad. But, get them to say that, no, the original charge is not for the administrator. And then you say, well, who the hell is it for then?
Good, all right. Thank you. That's all the questions I have. Thank you.
Okay, great. Thank you. Okay, moving on. South Texas. Go ahead. Did you have a question?
Yeah. I had a problem with IRS here in Austin, and I've been back and forth for about 2 years. I was filing OIDs in the beginning, and I was one of the few people I know who actually got my OID refund.
Good on you.
Well, yeah, but I mean, I messed it up. I made a couple of mistakes. I was silent. They sent me a notice of taxes due for the entire amount, and I didn't know what to do with it, so I was silent, and I fell into dishonor. And since then, it's just gone downhill. They levied the rest of the money out of my account. They filed a lien against me. And since then, they got me for frivolous filing, and I'm kind of a student. I'm a student of the Creditors in Commerce method of teaching. So, of course, I've accepted that debt for value 3 times, and I thought that maybe there was a problem with form, not necessarily the substance. What needs to be sent along with it, the 1040V, all these things. And so I'm left wondering, why exactly have I not gotten my remedy? Is it, it's one of several things. Is the IRS simply testing me to see how good a creditor I can be?
Absolutely, they're testing you.
Did I leave something out in form? I just have a lot of questions and no answers.
Well,
so
God only knows, and I'll tell you, the question you should be asking are to the IRS, and the first thing that I would ask the IRS, if they contacted you back and said there was a mistake with the document, do we want our money back? The first thing I would have said is, I would have asked, well, could you please tell me where the deficiency in the document is?
Mm-hmm. Well, I didn't know enough at the time. Maybe y'all heard about it. About a year ago, a plane flew into the IRS building here in Austin, Texas. That was
Stack, yeah.
Yeah, Just Act. But that was the federal building. I actually met this IRS agent before that happened, of course, several months before it happened. They invited me down, and again, I didn't handle it the way I thought I should handle it, knowing now what I know. But I walked in, and I asked a few questions, and she turned it around on me and simply said, okay, well, I don't know how you got paid that money, but now you owe it back to us. How are you going to do it? I said, I don't know. I guess I'll have to figure it out and get back to you. And so
Tell them to send you a bill.
Well, we've been that route. I sent them a bonded promissory note that came from a private banker. That seemed to make everything go away. I was fine for a year. I think I've missed something somewhere, because even though they stopped calling me and they stopped sending me letters for an entire year, the lien wasn't gone.
They're probably hoping you're going to send in another bonded promissory note, because they're going to collect on that one too.
Well,
they figure they got a sucker here who's just going to keep sending them in promissory notes that they can collateralize, or that they
that's
can
what I feel like. That's what I feel like. I feel like a cash cow, maybe, that they say, oh, no, wait. Maybe they'll send some more if he doesn't understand what he's doing.
Did you send in a letter, obviously with the bonded promissory note, with instructions to settle the account?
No, I didn't do that.
Okay, that's the first. So they just got a gift from you.
I suppose, yeah.
So that's one way of looking at it. So you may want to send them a letter to say, hey, did you keep a photocopy of that bonded promissory note?
Yes, I've got copies of everything I sent.
Good. Make another photocopy of it and send a cover letter with it saying, hey, remember when I sent you this and you kept it and never returned it? That was supposed to be for settlement of this account.
Well, I've done that.
Why didn't you do that? And that's what I'm now instructing you to do. Did you think I was just gifting you money?
Well, I think I've proven to them over the last 2 years that, I can threaten, but I don't follow through, because I don't know what to do to actually...
None of that was a threat. That was just saying, hey, remember this note that I sent you that you kept?
Well, I've done that several times. I've sent them conditional acceptances. I've sent them, notice.
But specifically for that note, that's what I mean. Did you give them instructions to use that note to settle that account, and then contact them afterwards and say, hey, that note that you kept was to settle this account. Why didn't you do it?
I didn't do that. But if I did it for the promissory note, I should probably do the same for the 3 acceptances for value that they sent. They sent me the notices on, and I accepted it for value once, and then I realized that I made a mistake on it, or I may have. I boxed in the numerical amount, and there's a 4 corners rule there, so I redid it.
You got to remove all presumption. You got to be very precise when you're contacting them and saying the photocopy of the promissory note that I've attached to this cover page was sent to you people. You never returned, which means you've accepted it. Law of offer and acceptance. Mm-hmm. This note was supposed to discharge this alleged debt, and then have a photocopy of whatever debt they're claiming that you owe, and then say that was the intent when that was sent in. Why didn't you set off this note against that debt?
Well, I suppose I could do that, but I think I've done even one step better since, which was I asked them for a notice of a statement of account. When I put 0 there, and they defaulted, and I got them in an agreement that I owe 0.
Okay. And now they're still coming after you again?
Well, yeah, because I filed 3 times. This was in 08, so I had to file for my 08 taxes, my 09 taxes, and my 2010 taxes, and each time we filed the OID. And, of course, their position is, well, you're not a bank. And I haven't raised any issues. You say, well, how can you prove that? Are you saying that I'm not a bank?
Yeah,
we haven't gone through that.
They mean a registered bank, not a banker.
Yeah, well, they've got my money. I've got them in a contract, again, where I told them, well, if you don't release the funds, here's my account number. If you don't release the funds, within so many days, you're going to owe me twice as much.
Yeah.
And they defaulted, and I got the three-step process. The opportunity to cure, and they just
Then you may want to learn how to put a civil claim together, put a statement of claim together, get it into civil court with all your exhibits and everything, and take that into civil court and actually take the IRS to court and sue them. And it's a very, very, very simple process, and it's even a lot of fun.
Fun, all right. Okay, well, is there anything that you teach? I'm kind of new at this. I only heard about you, again, a couple of days ago. Somebody in CIC sent me the YouTube link. Do you have any instructional videos on how you would go about doing that?
Well, like I just said to the previous gentleman, one of the things I would do is I would perfect my claim before I got there, which is a commercial claim, and that's just following. I revised and did a bunch of additions to like a Winston Shrout process for a commercial claim, and perfecting a commercial claim against the person you're going after, and then I take that commercial claim and I enter that as an exhibit into a lawsuit that I take then into civil court. And that commercial claim, which is the perfected private remedy, is the proof that you've already defaulted them on the private. And I think you're going to find that these people won't even file a statement of defense to your claim. They're probably going to lose. And as long as you can control the judge and not allow the judge to start defending the IRS when they don't reply, you're going to win. You're going to get a court order.
Well, I was about to do that in camera, on the private side. Some people think that it's probably better, since it's a private claim, to go the private route and send your notice, in camera to the judge, mark confidential, private, all that stuff, instead of bringing it to a public venue. How do you feel about that?
Well, it's almost along the same lines of what I just said, and the whole point to that is you got to remember that your private lien, like they call it a commercial lien, it is and it isn't. It's a perfected private remedy, which means that all you've done is you've gotten them, you've contacted your adversary privately, administratively, and you've settled the matter before you even had to go to court.
Right. That's what I want.
Now you have agreement of the parties before you even go to court. Well, now you've won there. Now it's just a rubber stamp for default judgment if you do it properly. So, yeah, whatever process you want to use to perfect administrative remedy first, do it. And then take that into the public courts to get a court order where they're going to be forced to pay you.
All right, one last question. I've heard from, again, there's a lot of information. What I don't have is a UCC filing on my claim, on my substance.
I don't do them. I don't think they're necessary.
Okay, so you've had success without the UCC filing?
Well, I've had a lot of success getting rid of charges. We're still in the process of collecting on the civil claims, but we know for sure that based on the civil claims that we've got in the courts right now, and some of them have been there for months and months now, is that the other party, which is the government that we're suing, they won't even file a statement of defense. They're sending their lawyers in to file stupid, ridiculous motions that the judge is allowing. And we're going to wind up having to add a couple of judges, I think, to our claim and take it to a higher court yet to make them learn their lesson once or twice. But we already know they're not going to reply to anything. They're just going to try to file stupid motions to have the judge strike your claim from the record or something stupid like claiming that it's a frivolous and vexatious filing. It's just nonsense. But these lawyers, they know better. They actually can't file a statement of defense. You're going to win.
Okay, you just reminded me of something. Let me just ask one last question real fast here. When it comes to UCC 1-207, which of course in the Uniform Commercial Code here in the States at least, do y'all have the same Uniform Commercial Code up there?
Yeah, the Uniform Commercial Code applies uniformly. That's why it's called the Uniform Commercial Code. It applies anywhere where there's commerce to do with the IMF nations, right? It was adopted by all that. I've got my UCC handbook right here. I've read all through it. That was a couple of years ago when I decided, you know what, this is not something for the common man. So that's why I don't include any of it in my teachings. I would say go ahead and do it if you understand it. But for the common man, I prefer to call UCC, I call it trustee law. That's the stuff that trustees need to know, and I'm not a trustee. So when an administrator gives an order to a trustee to do something, the trustees have to know UCC law and all this internal bullshit that has nothing to do with us. That's their jobs. We issue orders. That's what a director does, an administrator, right?
Yeah.
And then the troops do the work, and the troops are the ones that are supposed to know this shit.
Well, I haven't used it since it changed to 1-308, but I used to put on my tickets, I'd sign my name and then U period, D period, under duress, and then underneath it, UCC 1-207 without prejudice. And I got 9 tickets dismissed, one right after the next, including my son driving without a license. I've got the evidence.
Congratulations. Wow,
yeah, that's
great.
Well, I mean, but I want to go back to that. When it stopped working was when I got a fireworks charge. Fireworks, you know, who cares? But they wanted to charge me. And I wrote 1-207 and or 1-308, and it didn't work, and I had to go through court and everything, and they charged me $1,500.
Yep.
I got rid of it by filing some tax documents. I still don't know what I did.
This is what people have to realize, that the UCC is their code. This is all their laws, and they can choose to ignore it whenever they want. So it may work sometimes, but it may not work at all other times, and it may never work, period, for some people. To me, that's not a solution. If it's not consistent, it's not a solution.
What do you think they were doing when they dismissed them? I know that I'm trying to take jurisdiction away from them.
No idea. That would be making presumptions of what they were doing, and I don't do that. Who knows what they did? Maybe they just didn't want to deal with you, or maybe they actually obeyed the UCC, but they don't other times. It's hard to say what they do, so I just don't care.
Well, I'll keep doing it. I just wish I understood how it worked, you know.
Yeah, it's not for us to understand. It's their system. It's their system.
All right. Well, thank you, Dean. Keep doing what you're doing. Thank you.
Oh, you're welcome.
Thank you.
All right.
Hey, you know, before we get on to the next question, do you want to get a drink of water or anything?
Who's that?
You.
Oh, no, I got a big, giant bottle of pH-balanced water right beside me already.
Okay, good. And let's see here. We've got a lot of human lines, so I'm going to move right along. North New Jersey. Go ahead. Did you have a question for Dean Clifford? Oh, wait 1 second. I know what I wanted to say. I'll go over to that freemanitoba.com website and join in on the forum there. They have a section with a lot of documents that are also that follows it with what Dean's talking about.
Yeah, they're building a great little site over there. Actually, we're hoping to expand it and actually get some lessons on there and turn that into an actual homepage where people can go to watch the videos and everything as well.
You're cutting in and out. What are you doing?
Sorry?
You're cutting in and out.
Yeah, you're kind of cutting out a little bit as well.
Hello?
Hello?
Hi. I'm North Jersey.
Okay, go ahead.
Oh, I wanted to ask, maybe these are simplistic questions, I don't know, because I'm new at all this.
Simple is great.
But I'm already in the middle of a court case. I'm being sued for a credit card debt.
Okay.
So I've already, done whatever, filed motions as I guess what you would call that I've already contracted. Can I, in the middle of this case, now turn around and say that I'm the duly authorized administrator of my account? Or have I already sort of contracted? I don't know.
Well, you probably don't need to, because now you're getting into, this is civil court. You're being sued by a credit card company, right?
Yeah. Law firm.
Yeah. So you're being sued.
Mm-hmm.
Most of the duly authorized stuff to do with the administrators and everything is more so relevant when you're fighting criminal charges. When the state is coming against you, right? That's because it's kind of two different. Even though they're related, they're almost like two different branches of law. One's internal tribunal where there's no injured party. The one you're in, there's a credit card company claiming to be an injured party. Now here's the problem: the credit card company cannot prove an injury, and people don't know how to raise that point properly. There's actually a wonderful book on that, and she's probably listening tonight. And it's old material has been updated, and that's Mary Croft's stuff on contacting the credit card company and asking them to provide, number one, to provide proof of an injury, to provide proof that they even loaned you money in the first place and it wasn't your own promissory note that funded the loan, and to prove where the money that they loaned you came from. Just ask them 3 simple questions, and you can do that in court. You can file in the court.
But how in what context do I ask? I'm not in trial yet.
Okay.
I'm like pre-answer.
This is very simple then. So you actually want to contact they have a solicitor now. They have a lawyer, correct?
Yes.
And you have all this wonderful time in between your court hearings to contact them and to try to settle this before your next hearing. Because all these hearings is where the judge goes, okay, where are you guys at now? Oh, you haven't done anything? All right, well, we're going to do something today then, and I'm going to be the one doing it, right? So take advantage of the time you have in between the hearings, and you want to contact the law firm, and you want to say, hey, I got a couple questions for you before our next hearing. And if you got another hearing coming up right away, say, are you agreeable to an extension because I need some clarification on a lot of stuff with you guys.
Actually, I have an extension already. Well, the judge granted me an extension to answer.
There you go.
So I already have an extension.
Okay, so now you got some time to deal with this, right?
Yes.
And you only need 10 days, really. So you want to contact the law firm by mail, and you want to say, can your client, number one, prove the following? And then number one is, can your client prove an injury? Were they damaged? Have they lost anything? Have they lost any money? That's an injury, right? Well, they never did, and they can't prove they did because, it was your promissory note that generated the credits. So they can't prove that they've lost any money. Number 2, what are the other 2 points that I raised there? Number 2, where did the money come from? Can your client prove where the money came from? Or was the money not generated by my signature on the document, on the application I sent them in? And just send them a couple questions. There's a few more like that you can ask if you were to read Mary Croft's book that they raised on that about the fact that the bank can't prove where the money come from. The credit card company, they can't prove that they loaned you anything. That's another question you can ask. Can you please prove that the credit card actually loaned me anything or risked any of its own assets? Because if you haven't risked anything, it's impossible for you to be injured. And it just helps establish the fact that the credit card company cannot be an injured party. They do not have a bona fide claim against you. And then you want to file in the court that the credit card company was unable to prove a damage. They were unable to prove that they loaned you anything. They were unable to prove where the money came from. And then you can say, it's my understanding and belief that the credit card company generated the credits they loaned me by the document that I sent them that had my signature on it. Say, therefore, if I funded my own loan, how can I possibly owe them anything? And then you can make the argument, say, it seems to me that what has happened here is there's been an equal exchange of specie of money. I loaned them one form of money. They loaned me back another. That sounds like a fair trade. How can I then owe them anything?
Okay. I've already you're totally right. You're absolutely right. The only thing is I've already started with them denying this debt, that it's mine. I've already disputed, and I filed a motion to dismiss based on violations of the FDCPA. So if I turn around now I would be admitting the debt.
I wouldn't say that harms your case, but I'm not sure where the position would come from that it's not your debt at all, what your argument was on that. Oh, trying to say like it was the debt of the all-capital person and not you?
No.
Thank God, okay.
No. Actually, do you know, have you ever heard of What Lies in Your Debt?
No.
They have another system. It's more like use their laws against them and follow the court rules kind of.
Okay, and so
they tell you just deny the debt, deny it's yours. If they ask you if that's your signature, you say, I don't recall, that's not my debt, that's not my debt.
Ooh, yeah. You know what? I don't think I like the sound of that system.
That's what I'm doing.
Well,
and
no,
I
it's not like that.
No, that
not
sounds
like
that sounds a little dishonorable.
You refuse your signature because they present you with a copy. It's not the authentic signature, so how could it be your signature?
Well,
you weren't there.
That is a
right?
proper argument. That when they say, "Is this not your signature
yes.
on the document?" you can say, "No, that looks like a facsimile. Could you please provide me with the original
That's
so I can
right.
verify it?"
That's
a proper argument, and they will never provide you with the original because they've cashed it. They've got deposit stamps on it, and that would prove the fraud. That is a valid argument, but I wouldn't deny that that's my signature. Yeah, I would say no. That appears to be a facsimile of my signature.
It could be.
Yeah, could you please present me with the original document so I can verify that?
Aha.
Right. So demand to see the original document now. So that would go along with the previous argument you already made. Could your client please produce the original document for my inspection? Because you got to remember, no ink signature, no contract. No contract, no liability. So that's how you want to continue with that argument now instead. And even when they do produce it, then that would go on to, if there's, say, a deposit stamp on it, that means that the document has now been materially altered. Now you say, oh, I see. I think I see what's going on here. These guys use this document to fund the money to generate the credits they then loan me back. So it seems to me that we're even. That was a good trade. Thanks. Bye.
Wow. I don't know if my thinking is sophisticated enough to be able to.
It will. You'll be able to wrap your head around it. But always ask to see the original instrument. If there's no original that's what's going on with all those MERS foreclosures in New York right now, where all these people are saying, "Hey, the bank doesn't have the original mortgage document with my signature on it." They're trying to say they destroyed it or they microfiched it or something like that, and say, no. If you don't have my original ink signature, we don't have a contract. You're no longer the holder in due course, which means I owe you nothing. And they're right, and that's why they're winning.
Because the credit card company presented as evidence copies of account statements.
Well, copies of account statements prove nothing.
Yeah, not good enough.
Nothing. No. I want to see the original contract. The original contract. Account statements mean nothing.
Okay. Now, so if I ask these questions that you told me, do I file those questions with the court and then
ask their lawyer that first. Ask your lawyer to make arrangements.
Well, I don't have a lawyer.
No, their lawyer. No, their lawyer. No, oh my God, no, don't ever get a lawyer. Yeah, no, you want to contact their lawyer outside of the court now, and you want to deal with things administratively so that you have a progress report for the court when you get there.
Oh, okay, so I'm doing this privately, not through the court, because every paperwork I filed so far, I file it in the court, and then I send copies to them.
Yeah, no, you want to contact them directly and say, hey, before court this next time, I need to see this original document so I can verify I even have a contract with your client. Could you please have them produce it for my inspection? And when they don't reply or they don't, you default them, and then you make a motion to the court to dismiss all the charges because they have no original contract. They can't produce a contract with you.
And I probably give them a time frame, right?
10 days.
I say, you have this and this many days
10 days.
Produce. You have 10 days to produce this.
Yep, 3 days for them to receive it, 3 days for them to review it, 3 days to reply, and 1 day of grace. That's a standard in commerce.
You know
what? I would recommend that you watch his videos from start to finish, maybe 3 or 4 times. I'm already on my third time.
Yeah, I understand.
Because we can't do this whole thing on here. We've got 20 people waiting in line.
Sorry, yeah.
Okay, sorry.
Yeah, that'll help you immensely, though. Demand to see the original. All right.
Okay, thanks.
Thank you. Okay, Humble LC.
Hi, how are you?
Hi, fine, thank you. Did you have a question?
Yes, I do have a question. Back in 2006, I did file bankruptcy, and the house that I have was not reaffirmed. Since then, they have given me 2 modifications. Now they have served me with papers for foreclosure, and I have actually less than 28 days to respond. Am I able to use your techniques in this process or anything like that?
I don't see why not. Without really actually seeing what they're doing to you, what do you mean 2 modifications to a bankruptcy? How does somebody just modify a bankruptcy?
Yeah, and I didn't understand that either because if it wasn't reaffirmed, there's no loan to modify at that point, correct?
if anybody's going to modify an agreement, then they got to have agreement of the parties. You can't modify something without agreement all around for whatever party is a party to that document, to that agreement. I would send, even though it's been a while, hopefully it hasn't been too long, I would deny the modification. Mm-hmm. Revoked by administration, overruled by administration. Say no. Say you don't have my agreement to modify this existing agreement.
Okay, but we did sign off on that, saying that we did want to go ahead and modify it.
Oh, okay. Okay, well then they have agreement with you. Foreclosure, for staying foreclosure proceedings, the same thing as the lady that we just finished speaking to. I would ask if you owe money to who? The bank?
Right.
Now you want to start the whole show me the original mortgage document argument.
Okay.
I want to see the original mortgage document, present it to me so I can verify the signature. You could try paying it with a promissory note. Say I want to pay off the mortgage. Present me with a settlement, and that means because you got to remember, a mortgage is an offer to pay with future obligations attached to it. Right? A mortgage is a little bit different than the promissory note. It's got obligations attached to it, future income, future profits. Mm-hmm. So when you ask a bank for a settlement, say how much to buy out this mortgage now. What's it worth right now if I want to buy it out? And they'll present you with a settlement offer through their law firm. So they'll have their solicitor present it to you, and then as far as I'm concerned, you should be able to pay them with a promissory note. But definitely go the same way that everybody else in New York's going, and a lot of people in the States are, demand to see the original mortgage document.
Okay.
With your ink signature.
And I would actually go to the bank or their lawyers?
Well, their solicitor. They have a solicitor now. That's who's representing them. So you always talk to that guy now, and you do it outside of court.
Okay.
Yep, and if they don't produce it, then you would contact the court and you would make a motion to stay or to dismiss this foreclosure, based on the fact that they can't produce the documents that you even owe them any money.
Okay, now
they can't produce the contract.
So say, for instance, they do produce the note with my signature on there.
Yep.
I guess it would be...
They won't.
Okay.
That's the beauty of it, because they've deposited that, they've sold it, it's probably got deposit stamps on it.
It's been shredded.
It's been materially altered or registered. That basically proves that the bank deposited it, and that's what generated the revenue, generated the credits for the house. And you can make that argument as well too. You can feel free to draft a document to send to their lawyer to tell them that it's your understanding that the original mortgage document you filed with the bank was deposited on their books, and you believe that's what generated the credits that then paid for the house. Say, so I've already paid for it once. Why do you want payment again?
Right.
Now they have to rebut that and say, no, that's not what happened.
Mm-hmm.
Well,
okay.
Good. Prove it.
And so, say they're not going to produce it, and then I will respond to the courts with what again?
Well, they didn't produce the original mortgage document. So how can I? How do I know there's even a real mortgage on this place?
Okay.
Right. And then the other argument is, well, if they've got this mortgage document and they deposit it onto their books, it's my understanding that generated the credits. So the same thing as a credit card company, we just exchanged species of money. So how can I owe anything? And not only that, if there's an interest rate, so if you gave the bank $100,000 and they gave you $100,000 back. Mm-hmm. They loaned you $0.
Exactly.
Now there's interest on that. If there's even 1 penny of interest on $0, what is that interest rate? Infinity.
What? Right.
That's an infinity interest rate. Well, isn't that a criminal interest rate?
Exactly.
Right?
Okay. Exactly.
Oh, I thought these guys are criminals. They're charging infinity interest rates. I think I have a claim against them, actually.
Mm-hmm. And that's what I was wondering, too. Once this process goes through and they don't show me the note, am I able to sue them?
Absolutely.
Turn around and sue them for
Absolutely. Set up your claim, contact them, get commercially default them, and then take them into civil court and sue the shit out of them.
Oh, yes. Oh, yes.
Yeah, it gets to be fun.
Okay. Yeah, but nowadays they're making color copies of notes. You've got to make sure you see the actual. The thing is, if they don't provide the note, then anybody could come back to you later on and say you owe this amount of money or that amount of money.
Yeah.
Oh,
here's another.
So they have to do it.
Yeah, based on that, here's another great question to ask them. Say, if I pay out this mortgage tomorrow, will you return the original note to me?
Mm-hmm.
Right. They're supposed to mark it paid and hand it back to you.
Exactly.
That never happens.
The original ink signature note where my pen touched the paper, I want that stamped paid, and I want it returned to me as a condition of me paying off this mortgage. Is that okay?
Right.
They're probably not going to. You're not probably not going to hear from them again. Maybe after that.
And so
yeah, somebody put money in escrow, the actual amount to pay off the loan.
Exactly.
And that was, they said, if you get the money's in escrow, you can have it as soon as you provide for me the original note with my blue ink signature, and it never happened. So,
as far as the promissory notes, like how do you go about writing those up?
Look it up online. There's so many sources for promissory notes, and one of the big ones I like is actually just download the United Nations Convention on International Bills of Exchange and Promissory Notes and read that, and it actually tells you how to construct one.
Oh, excellent. Okay.
Yeah, so there's a little bit of reading again that goes an awful long way.
Not a problem. Well, thank you so much.
Good.
Oh, you're welcome.
Thank you.
Bye-bye.
Very good. Bye. Okay, Northeast California. Did you have a question for Dean Clifford?
Hey, Dean, how you doing?
Not too bad. Yourself?
Well, I'm in a situation, but first off, yeah, obviously I'm in a situation. Thank you, and I'm a truck driver, and I have it on the Dean Clifford channel all day long while I'm driving. But as you know, the government tries to regulate when I'm tired and when I'm not tired.
Yep.
And so I got a log violation ticket.
Okay.
Now here's the problem. 21 days for pleading in Virginia. I've missed the pleading time, and I missed putting in my affidavit, which is your affidavit, by the way, that you have on the site there.
Oh, I got an affidavit up there? Okay.
Well, your sample affidavit, I'm not a government.
There's several of them. Yeah, on the forum. Yeah.
Yeah, on the forum. So anyways, I'm past the 21 days. The ticket, I'm up to the point where now I got to sign the ticket, turn it in, and I wish I was smart enough to put two and two together really quick, but I'm just going to ask you really quick. How do I sign a ticket now that I'm guilty and put it in? I can't lose my license.
Well, you're never guilty. Yeah, you don't want to lose your license. I'm not sure what the violation, how much of a penalty it carries with it, but is it like any other kind of a traffic ticket where you get you probably have a pink copy?
Well, it's just a summons, and the problem is they have these scores now, these CSA scores, and every ticket I get, it goes against my score, which means that it's harder for me to get another job with another company.
Yeah.
If I have a high score.
See, that's the whole problem with that is when people actually do depend on their trucking career, you really almost can't start messing with the system because they really got that locked down tight. Like that is commercial trucking. That's most companies you work for are terrified of like the Department of Transportation and all those kind of organizations. That they're not going to look lightly on you, kind of like pulling a lot of this free man stuff. The only thing I would say you could try to do is to try to get the original ink signature charge. The same thing that I've been saying with everything here. If they're going to refuse to produce the original charge, whether it's got an ink signature of like a cop on it or something, or whoever issued you this ticket, I don't know who issued the ticket to you.
The state of Virginia. It's just a normal summons.
Okay. So it's a summons for like criminal court kind of thing for a driver's license.
Yeah, for the 26th of this month.
Okay. Well then, yeah, no. You go down to the court wherever you're supposed to go deal.
I can't. I'm a truck driver.
Oh shit, that's right. Okay.
I'm 1,000. At any one time, I'm 1,000 miles away from Virginia.
Okay, not a problem. Then what you would do is you probably don't have the time to contact them by mail either. I would just write, if you got access to a computer, write a little cover letter that said that when this ticket was issued, they failed to give you the administrator copy, the copy that's supposed to be for the administrator with the ink signature on it for me to settle. And then what I would do is I'd take a red Sharpie, and I love doing this. And so you take the copy that you have, which is probably obviously it's got the facsimile signature on it, right? Because it was like a carbon copy.
Oh man. Shoot. Of course, I'm so prepared. It's a yellow ticket copy.
Yeah. The signature is obviously carbon copy because it's a part of a carbon copy of the document, right?
Yeah, because I can barely even read the
there you go. All I do for that is I take a red Sharpie, like a red marker, and I write at the very top of the document, new original. So you're the administrator, and you're making this the new original copy because that's the only one they provided you with.
Okay.
Right? So this is now the new original document. And then now you can do one of two things. You can accept it for value and sign it, and sign above wherever their signature is. Make sure you AFV it and sign above their signature. and then send that back to the courthouse and just mail it to them. Regular mail if you want to stamp it. Keep a copy, though. And what I like to do is I like to go, if I'm going to send it regular mail, because why pay $8 for registered mail if you don't have to, just get the post office to stamp both the photocopy you're going to keep and the new original that you're sending back, and then mail that to the courthouse.
So sign it above where my signature already is, or sign it where the officer.
Oh, that's right. In the States, you get. Oh no, your signature's already on that document.
Yeah, I promise to appear at the time and place shown above. Signing the summons is not an admission of guilt. Yeah, whatever. You know. So.
Yeah, they make you sign them here.
Yeah, they make you sign them down there. I forgot about that. Okay, well then. Aside from that, you could still try the AFV process like that. You don't even worry about the fact that you sign below them. That's that whole underwriter and overwriter argument. I really don't care about that anyways.
Just so what about like you always say, you know, can I be bound to contract without full disclosure or something to that effect?
Yeah, well, number one, you're obviously forced to sign that document. Were they going to arrest you if you didn't sign it?
Correct.
Okay, then one of the things you could also try is just I'd take the same red Sharpie instead and just write diagonally across the document, no contract, dishonored, and then I would underline my signature with a little caption beside it. And I had my brother do this, actually. God, I use him for a lot of examples. He's like a guinea pig for a lot of this. And then right beside the signature that has an arrow pointing now to the red line under the signature, I just write in red Sharpie right across the document, I was physically threatened to sign this, no contract, no consent, and send that back to the courthouse. Now you've let them know you didn't sign that voluntarily, so it's not a contract.
Okay, I didn't ask the cop what would happen, so can I just sign it that I signed under protest and duress, maybe?
Well, was he armed?
Yeah, he was armed.
Was he acting in a threatening manner?
Well, not really. He was nice.
I guess, yeah. But I guess you guys know down there you're going to be arrested if you don't sign these things, right?
Yeah.
Yeah. You can always put on there, I believed I would have been arrested if I didn't sign this. You could put that. Because you want to be honest. If you believed, honestly, that this guy was going to arrest you without warrant, if you didn't sign that document, then that's what you put on there. People have to remember that none of this stuff is ever showing up in the court, right? When you get arrested, thrown in jail, beaten, dragged before a judge, how many people say on and for the record, I was arrested without a warrant, beaten, and dragged before you, and I'm in handcuffs right now? People never say it on the record, so it never happened, right? So you got to start getting this, and it's pretty easy to see now because you've written it right on the document. Well, number one, I'm no contract. I'm dishonoring this. Why am I dishonoring it? Well, somebody presented this with me at the side of the highway who was wearing a gun, and I felt pretty threatened at the time.
Okay, and then part two, I have a question too about the. So part two it says, a waiver of a trial, plea of guilty. So if I signed it there, dated it, and if they were to send me, I really don't want that. But you mentioned that let's say I did sign it guilty, and they sent me a bill. So would I just, which is not what I want to do. I want to do what you just told me to do. But the theory behind, I sent them like hypothetically, I sent this in, signed it, and they sent me a bill. And then I would send them a letter asking for the check to go with the bill too.
Well, no. If they send you a bill, a proper bill has to have a signature on it. And if it's going to come from the court, it will. It'll probably have a magistrate's signature on it or whatever they call it down the States. Now you got a document that's already got a signature on it. You sign above them, you accept it. The bill's paid. Done. So try that. Absolutely. Why not? There's a million and one solutions to this and remedy if you want to try it and just experiment. But absolutely, that should, by theory, work.
Yeah, but my fear is that I'm a truck driver. That's, and I have a commercial license out of necessity.
Yeah.
So I consider that protest and duress.
Yeah, the only thing I'd say to that is unfortunately, and people hate to hear this, if your career depends on it, then play by the rules.
Yeah,
Sorry.
I appreciate thank you so much, Dean.
Yeah, either that or try a couple of those things just to see what happens, man.
So I should make a copy of this, but put the yellow, put the no contract, dishonored, and then what if they come back with, well, go screw yourself, you're a truck driver, you're a commercial driver, blah, 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 you should know better, blah, blah, blah.
Then deal with whatever they send you.
Yeah, okay.
Yeah, unfortunately, It's all trial and error, man.
Okay, I appreciate your time, and I am a member of Free Manitoba, and like I said, I listen to you all day long. And
awesome. Then send me a call or send me a message and let me know what happens with all that.
Okay, I appreciate it.
Perfect.
All right, thank you, Dave.
All right, thank you. We're going to move on to Will Siam. That's a cute name. Will Siam?
Yes, can you hear me?
Hello.
Yeah, I can now. Go right ahead. Did you have a question?
Yes, I do. I got involved in all this stuff, and I never would have otherwise, getting into a colossally horrible family law situation.
Okay.
And of course, like almost all these the really oppressive family law situations, one of the strategies to isolate you from everybody else is to take a situation that fundamentally to begin with is really simple and make it really complicated.
Yeah.
And really simple to begin with is that I was in a marriage with a couple young children, and my spouse really didn't want to contribute all that much to a marriage and kids, and certainly nothing financially. But she wanted lots of money, and on a bad day, that looked way better than the marriage, which is pretty much the same for everybody else. Well, she went to some government officials at different times because people told her, oh, well, if you take control of the situation, you'll get a whole lot of money and you'll be rich for life, and that was very, very appealing to her.
Yep. Usually is.
But none of the government officials that she went to would help her, because she clearly wasn't taking responsibility. She was starting to act very mentally strange, and even though she is a woman and a very presentable looking woman, she would be a total embarrassment for any government official to help her. So she was denied help to get money, and I mean, it was like I was a single parent with a professional career of two small children and an adult wild child.
Okay.
And but I was doing some work temporarily in the banana-shaped republic on the western side of the United States. And they have a law there that this was written by this DA's office in this county that we never set foot in together, that basically said if they can get a signature on a piece of paper assigning rights to the kids over to a county, and that parent can keep the kids, but then they belong to that county, even though normally in the United States, you're supposed to be someplace 6 months for the whatever jurisdiction to have some claim to children or family or whatever. But they got this law passed there that basically said, well, to boil it down real simply, what it said was,
I would appreciate that.
When I filed paperwork, still thinking the system worked, where we actually lived and could have witnesses and have some semblance of a fair hearing, which was, of course, a different location where we'd actually been living.
What's your question, young man?
Well, anyhow, there's a situation. It's not a unique situation where some county could take some jurisdiction could take complete control. Basically pretty much no matter what, and if you go against them, then like just to try and get a fair hearing of what's going on with your own children, your own family.
So the state took custody of your kids?
Yeah, they're saying that. Well, it's like
number one. I don't even need to hear anything more. If the state took custody of your kids, you're going to want to look up something called United Nations Declaration on the Rights of the Child.
Yes.
You look up that declaration, you swear out an affidavit that the state kidnapped your kids, and you serve that on the state. and you send them excerpts from the United Nations Declaration on the Rights of the Child, and you let the state know they have no authority to take your children, there's no contract in place between us for them to have taken your children or to have jurisdiction in the first place, ask them to produce the contract. If they don't, they've agreed with you they don't have a contract, which means no jurisdiction. That's what jurisdiction means to these people. It means a contract. They have no contract, period. It's presumed. You want to sue them in civil court after you've established all these facts, along with filing affidavits and quoting parts of the United Nations Declaration on the Rights of the Child, which says that that the state cannot take your children away. They cannot. Just read through the act, the United Nations Declaration on that. It says right in there. So you just got to quote that act, send them a copy of it. I'm pretty sure the United States is a signatory to that. And if they're not,
and I have that electronically on my computer. I just couldn't figure out any way to get any enforcement on that.
Well, you're the only one that can enforce it. You have to send a copy to them and ask them if they recognize that document. Are they going to respond to you and say no? If they do and say that, great. Especially if the U.S. is a signatory of it, then you sue them. You sue them because the United States is obligated to obey that document if they're a signatory to it. You can also quote the Bible, and please do, especially if you're going to be going into civil court, because that's a common law court. So the problem is what you have to do is you have to learn to start contacting the state, telling them to return your children because they have no contract with you. When they don't reply, you start to issue them fines and let them know how much it's going to cost for continuing to deprive you of your children. And then you sue them in civil court, and you use things like the the United Nations thing on the rights of the child. You add that to an exhibit. You add that as an exhibit to your lawsuit, because you're going to be quoting that in part of your affidavit that's stating that the state has no standing or claim to your children. And you sue the shit out of them. And again, the affidavit is the plain statement of facts. The damages are what is the result of what happened, which is the loss of your children, and the remedy is their return and the fees for them non-complying with your order to return your children. You are the court, you are the sovereign, you issue orders, you're the administrator. You send them a letter and you order them to return your friggin' children. That's it.
Yeah, and of course they also absolutely obliterated a completely successful career I had by
and that's another damage you take to civil court.
Yeah,
that's it.
And you know, I just want to be left alone, but I need some resources to function with. You're not
going to be left alone until you enforce your rights.
Yeah,
that's when you'll be left alone. Because until you do that, they don't give a shit.
Okay, so I go to this treaty, and I'm filing in a civil court.
Yeah, you want to get a civil claim, a statement of claim together to take into civil court that has an affidavit built into it, where when you're suing the state, an affidavit, you want to make sure that's in your statement of claim, and in the affidavit you're going to be, you know, when you state certain points about your children, like your rights over your own children, then you have in brackets Exhibit A, and Exhibit A in your lawsuit should be that document. Just go online and download a bunch of statements of claims that have been filed into the courts to see what the structure is of a statement of claim, and then start to build your own using that as an example. Okay?
Okay, and the affidavit you were mentioning before, has three different parts, basically?
Well, no, the affidavit is one part of your statement of claim. A statement of claim, or a claim period, has three parts. That's the statement of facts, which is your affidavit. Then it has the injury that happened as a result of the statement of facts, and then the remedy, which is what is it going to take to settle the damages. That's the three components. If you have those three components, you file that properly into civil court, you will win.
Okay. I can certainly go ahead and process that. I've kind of lost faith of getting any
You've lost faith because you haven't done anything yet. You've been operating in the private, trying to negotiate with the state.
You wouldn't believe what I've done.
Oh, I believe it. I'm helping somebody right now who's been doing it for 4 years in Canada up against Child Family Services. And as soon as she started doing what we told her to do, the sparks started to fly and people started to shit their pants.
They've already used this statute that
It's a statute. It has no force and effect on you. And if you think it does, then you ask them exactly where does this have any force and effect on me?
Yeah.
That's the only question you need to ask them. It's not a law. It's a statute. Some assholes in an office somewhere passed it. How does that make it applicable to you? So you ask them that and do it on the record with a registered mail filing.
Yeah. Okay. I've been fighting them for almost 10 years now.
You haven't been, well, it's doubtful you've been fighting them. I think you've been arguing with them, but you haven't done anything properly yet. So do what I told you to do and get it into civil court and file it properly and look at some examples online.
Okay.
All right?
Yep.
All right, great. Thank you so much. We're going to move on to guest number 16. There you go. Hi. Did you have a question?
Hi. Yeah, it's Nicole in Kelowna, Canada. Hi, Dean. Hi.
How you doing?
Kudos to all of you. You know, you're honorable, and we'll all prevail because of this. You really, really empower us. So I'm breaking some ground rules over here, and I think I am. Yeah, well, I am. It's in court, and I will be making some precedents if I am successful. Now it's not a bank. It's a computer company that gave me my mortgage.
Okay.
And what I do is I challenge the validity of the alleged contract. I put in a civil claim. I did my 3 administrative remedies. I did the notice to proof of legal standing. I did the notice of fault and opportunity to cure. I did the notice of dishonor and default. And I didn't perfect. And I'm an avid Winston Shrout. I mean, I love the guy. But I love you, too, because you say it in a Canadian way.
Yes.
So it's better for us here, us Canucks, right?
Yeah.
So simply put is that the petitioner, because now they put in a petition after my civil claim, I knew I had a year to do it, and they knew that I wasn't going to do it right away. I asked them to produce the instrument of indebtedness, like that Jersey girl, right?
The mortgage document.
Yeah, the mortgage document. So therefore, there's no competent evidence that any party is the holder of the alleged note and the true holder in due course.
Yeah, you want to know who the holder in due course is.
Yeah, proof of perfection of the security is by actual possession of the security, right?
Well, yeah, because if you're going to pay a debt, you want to make sure you're paying it to the holder in due course,
yeah,
so you can get a paid receipt that shows and get your original document back. Otherwise, anybody could collect on that in the future.
That's right. But you know they bifurcated it, they sold it. You know they chopped that puppy up, right?
Oh, who knows what they did with it.
Right.
So did you have a question?
Yeah, there's also an inference of inequality of obligations where the petitioner loaned the respondent's own credit and is demanding money of exchange, right?
Yeah, you guys just exchange money, if they a species of money.
Yeah, which you've been saying all along this talk. Now, what do I do? To do it simply, should I just say present me with the original charge, the original note?
Present me with the original note. Yeah, the debt obligation. Present me with the original document that gave rise to this obligation. Where's the original?
And then again, where's the other side statement of defense? They have none. I mean, like, how do I go about, like, I'm going to get a hearing here soon.
Yeah.
And at the hearing, you know the judge is not going to allow this to fly.
So the other party has filed no statement of defense?
Yeah, they said that I'm full of baloney.
You're the one that's defending.
And they want to foreclose it. No, they're the petitioner.
So they're the plaintiff. You're the defendant. Okay, so it's up to you then basically to defend your position and say that they're not producing the original note.
Yeah, so I've done all that, and now I'm waiting for a date here.
Yep.
You know the judge is going to kibosh this somehow.
I don't think so. Have you motioned to the court yet? Have you motioned the court to dismiss their to strike their claim with prejudice because they haven't even proven a damage? They haven't proven that you owe them money.
No, in my response, I just opposed and do not consent to each and every point that they've had. I've used some legal basis, some rules out of their own books, the Bills of Exchange Act, all kinds of stuff. But you know what? They're not going to listen to this, are they?
Of course, they're going to listen to it. I think there's the Fair Debt Collections Act. I think that's the name of it. I could be wrong on that. There's points in there that say that basically, unless they're going to produce the original debt, you're under no obligation to pay it. There's something in there about that. And if you were to put that in your statement of defense, have you contacted them outside of the court and asked them to produce this note?
Originally, the company, not the lawyers. Yes, I did.
Okay, then you want to do it again with the lawyers now, because when you contact a lawyer now and you do it registered mail, you can default them. Do it again, and state in the contact when you contact their lawyer, by registered mail, say I contacted them more than a year ago and asked them to produce the original note and they refused. So I'm asking again, where is it? Because it's not in your statement of claim. Where is it?
Okay. And by rights, everything can be done by email now because everything can be tracked.
Yeah, it's all admissible. I like faxing things, actually, and then calling down there and asking if they receive the fax. Faxes are great.
I get the okay confirmed sent there?
Yep.
Yeah.
Yep.
Okay, so you guys all listen up in Kelowna, British Columbia. This is going down soon.
Yeah, get your process right and you'll win.
Super. Thanks for your time.
Thank you. Okay, we'll move along to who's next? KMA Club. Hi, Dean. Go ahead. Did you have a question? Dean?
Hello.
How you doing, Dean?
Not too bad. Yourself?
Oh, pretty good. I'm a truck driver, too, and I got a ticket, and the cop didn't even have me sign it.
Okay.
And I got an extension because I was going to file the stuff in there that Rod Class has filed into his suit. I don't know if you heard about that in North Carolina.
No.
In his lawsuit, he's got in there that they cannot take your license. They cannot do anything with your license because they are not part of the FMCSA, who is the federal DOT. That's who is in charge of issuing license. So only the issuer of the license can take the license. They're just contracted to take your picture and pass them out. That's it. And in that also, he says in there, he claims that if the police officer that pulls you over is not FMCSA DOT certified, that they cannot pull over a big truck, somebody in commerce.
Okay.
So I was waiting to file that in there. So I'm wondering now.
I would say you should send a quick letter to the police that issued the ticket. And ask them to provide the written delegated authority to enforce the statute against your license. Is what you're saying. Is if they lack the authority, then you ask them for proof of the written delegated authority to even issue that ticket.
Okay, and because he didn't get my signature, doesn't that mean something too?
If you didn't, well, I mean, no, we're not forced to sign our tickets up here in Canada either. That if it's left open, but then you can also use the argument of. If you don't sign it, you could just write refuse. You could accept it for value sign above them. You could just refuse it outright. I like to put refused or dishonored by non-acceptance in red marker right across the ticket and send it back to them without signing it. Refused by administration. There's a million different things you can write on it as long as you're making the point that you're refusing whatever you're presented. I'm refusing this. No, thank you. Piss off. So
because the main thing, like that guy was saying a while ago, the main thing we got to do is keep the points off.
Yes, that's the problem with you guys, because you do have to keep your commercial licenses, technically speaking, just because of the companies you're working for. And that's the thing. If they lack the authority, which is what the argument you were talking about there at the start was, then you may want to contact them and ask them for proof of their written delegated authority to issue that ticket. If they don't have any written delegated authority to do it, then the ticket's void right from the start.
Well, I did bring that up with the deputy that wrote me the ticket, and I said, if you don't have the FMCSA certification, you can't even pull me over. Yes, I can too. I pulled you over for a traffic ticket. I said, that's just it. You can't do that.
Well, okay, now what's the that gets into the argument about what's traffic and stuff like that, and what they have jurisdiction over. So it all you know what it all boils down to. It all boils down to how much do you want to fight? How much is it worth to you? Sometimes is a ticket just worth paying? But if that's all, if it's points, I mean, you could always, you guys are gonna have to try some of your own remedy on that. But you can start with the written delegated authority or just refusing it outright. But you might end up having to go to court and defending your position with just saying, well, no, I refuse to contract with these people. They have no jurisdiction over me.
Yeah. Well, that's basically what I was going to try.
Yep.
And basically do it like you just now told that lady. Go in there and as administrator and tell them, okay, I don't. You haven't been given consent. You don't have the jurisdiction, and so I demand that you
don't say that to the court though. The court does have jurisdiction. It's the people coming against you that don't have jurisdiction to drag you in there.
Okay.
That's a very important part people have to realize. People are going into these courts and they're challenging the court's jurisdiction. The court has jurisdiction to hear whatever your adversary is bringing in there. The problem is your adversary doesn't have jurisdiction to bring you in there. You're fighting the wrong people. Don't fight the court. Fight the person bringing you in there.
Okay. Okay. I understand that.
Yeah, that's very important. And you can't challenge jurisdiction in a court anyways, because a court can't make a decision on its own jurisdiction. No man can rule in his own cause. And you're just going to piss the judge off by doing that. Right?
Okay.
That's what you want to do.
Okay.
So you want to, and you could do the other thing too there with asking the court to present you with the original charge. I'm the administrator. I'm here to settle. I'm duly authorized. Give me the original charge. When they give it to you, don't accept it. Just write not accepted, refused, whatever you want on it. Doesn't matter. You've just canceled it.
And that works by itself?
I don't see why it wouldn't. What are they going to say? You can't do that?
Yeah.
Well, I just did it.
Yeah, they're hungry for money up here, down here.
Yep. Yep. Say no, thank you. I don't wish to contract with these people. Offer refused.
Huh.
And again, there's the other argument you could make. Well, just because I have this light, well, we're getting into commercial trucking now though too. So the whole thing about just because I have a license doesn't mean I was operating it at the time of the complaint. That's always a good argument too. But you might not want to get into that because you are going to need your license for gaining a livelihood. So.
Well, the thing is, I don't have to worry about working for somebody else. I'm an independent trucker, so I own my own business and I drive for myself.
Okay.
And I've got a contract to haul for these people that I just now dropped the trailer for, so they like the job I do for them. And the guy that what do you call it? Transportation manager. He's been a driver, and matter of fact, he's still got his CDL. And he knows what kind of clowns they can be.
So if you were engaged in a private contract at the time you were pulled over, what has the state got to do with that?
Basically, the way I look at it, they got nothing to do with it.
There you go. So you might want to bring that up with them. Say, excuse me, I was engaged in a private contract at the time of the complaint. I was not performing a function of government or anything else you have jurisdiction over. What's your standing in this matter?
Ooh, cool.
And you would still aim that at the deputy that pulled you over, not the court.
Well, now it's going to be against the state because it's going to be a state prosecutor coming against you, right? County prosecutor, I guess. Yeah. There you go. So your problem is now with the county prosecutor if he takes it to court because he's assumed liability for what the deputy did.
Okay. So I can put the paperwork in first, see if I can stop it that way, and then if I can't stop it that way, then go into court and defend it that way.
Yep. And I would start. People can get into things like counterclaims and fining the county for getting involved in your private business. Get out of my private business, or I'm going to fine you.
Okay. Well, what he was saying is he had the right to pull me over and he was looking over my trailer, and I said, unless you have a FMCSA certification, you can't look over my rig to see if I've got anything wrong. You don't know what you're looking at.
Well, not only that,
if your tires are bad and all this stuff. I said, yeah, you're not allowed to, though.
Yeah, the statutes, the little statutes you're talking about only apply when you're going to be doing work for the government anyways. Not a private matter. Even though you have a plate, a state plate on your truck, and you have a state license, that doesn't mean that you're using it at the time of the complaint. Because you were engaged in private commerce at the time they detained you, were you not?
That's right, I was.
What do statutes have to do with private, with private contracts? Nothing. Statutes only apply to contracts between you and the government.
Okay.
So take the ticket, fight the county prosecutor. Don't get into it with the cops at the side of the road because they don't have the authority to do what they do, but they're going to do it anyways.
Yeah, because they've got a quota to meet. Yeah.
They got a gun. They'll shoot you.
Oh, I did ask him that.
They kill people,
Yes. Yeah, don't argue with them. Argue with the prosecutor when you get to the court.
I asked him, I said, is that thing loaded? He says, yes, of course it's loaded. I said, okay, duress and coercion. All right.
There you go.
And I I think that's why he did not have me sign the ticket.
Probably not. So there you go. That better be in your affidavit that you're sending off to the county prosecutor.
Yeah. Oh, and then another thing is the main reason he pulled me over, I was riding the left lane. I told him, I said, safest place for me to be is the left lane. I said, if I'm on the right-hand side and you've got somebody pulled over up there, what do you want me to be? Left-hand lane. I said, when I'm riding in the right-hand lane and a car wants to get up here and get off at the exit real quick, guess what they do? They run down the left lane, then they jump over in front of me, hit their brake, and then jump off. And I saw, what do you call it, North Carolina cop do it yesterday in front of another truck. I was in the left lane, and he jumped right in front of this truck in the right-hand lane.
Yep, exactly. I would say if you got a problem with me driving in the left-hand lane, write me a ticket for it.
Yeah, and he got me for 7 over instead.
Yep. Yeah, they'll do anything. Yeah, they're idiots, but don't argue with them. It's pointless to argue with a meat puppet, and that's what they are. They find the most stupid people they possibly can who are on an ego trip to pull you over just to argue with you and get you to fight so they can shoot you if they really feel like it. They're idiots. Don't try to reason with them or use logic with them. If you want because you're engaging in private commerce on the public roads, which you have every right to do. Send the state a letter saying that when you're engaged in private commerce, which is non-government contracts, if their state friggin' troopers bother you and pull you over and detain you one more time, you're going to sue the state every time they do that for $50,000 and start setting up fee schedules for that. And then when they pull you over, take the ticket. Yep, thank you. Oh, please give me a ticket. That's worth $50,000 to me, plus the face value of the ticket. Make sure you give me the original white copy, by the way.
Yeah, and that's what he gave me the deeper pink copy.
Yep.
Not,
Hand it right back to him. Hand it right back to him. Say, no, you must have me mistaken for somebody else. I'm the administrator. Give me the original.
Yeah, that's good to remember.
Yep.
Well, I appreciate you coming on here tonight. I appreciate you, Angela, getting a hold of you. This has been really enlightening.
Hey, I hope it works, and I hope people send me some success stories. We got to start fighting these people. So
I tell you, I really want this to work for the truckers because we need to get Ray LaHood and all them crooks off our back.
Well, you guys bring the food to the supermarkets. I'm sure everybody appreciates that, so I'd prefer they leave you alone, too.
Okay. Thank you, Angela.
Oh, you're welcome. Thanks, Dean. All righty, moving right along here. West Maryland. Go ahead. Did you have a question for Dean Clifford? West Maryland. Oh, West Maryland. If you've got a mute button on your phone, press it. Otherwise, I'm going to have to move on. West Maryland. West Maryland. Okay, we're going to move on to, Dance Forever. Dancer Forever. I'm sorry, I should have got back to you sooner. Go right ahead.
No problem. Yeah, about mortgages, especially foreclosure defense. We've been talking a little bit about that tonight. Hi, Dean. Hi,
hello.
Angela.
Hi.
Been studying this a little bit, and know that John Stewart in your website, Angela, talks a lot about trust law, and I'm just curious how that relates with Dean's, trust law defense also at the same time. I was wondering, I'm sorry?
It's a little different. The trust part that John Stewart talks about, it has to do with the trustee. When they go to foreclose on you, there's a trustee or an assignment of trustee, and there really is no trustee. So you can sue for fraud just because there's no real trustee. Okay. And there's no note and there's no loan. John also says, show me the loan.
Right.
But go ahead, Dean. I don't know what's your take on it.
I don't even.
As far as the fact that how MERS claims that they're the beneficiary. Okay, that's one thing, and then they securitize the loan, and then they make their own, grantor depositors, and they have their own positions for everybody in that particular trust. And I know some people have created their own trust in what is called asset protection, basically. And anyway, I was wondering, if we can go apply some more things to that and make your own where you're the executor. And anyway, can you give me some ideas as far as that, Dean, maybe?
Okay, now, so specifically speaking for a foreclosure on a house like you were talking about originally there?
Yeah, when, people get a notice of default and acceleration of the, acceleration notice.
Based on what was said there by Angela, actually, to be honest with you, I don't think they're, even though this individual claiming to be a trustee may not be technically a real trustee according to law, if somebody's claiming to be a trustee, I think that's great. But by your actions, you are a trustee. If you're claiming to be a trustee, you are. I think that's great if somebody wants to appoint themselves a trustee because now they can't get out of the appointment.
Right.
I would appoint whoever's claiming to be the trustee. I would appoint them as the fiduciary trustee in the matter. Say, thank you for being a trustee in this matter. Now, as the trustee, I need you to go and get the original mortgage document from the people that are claiming that they have it.
Oh, but see, in John Stewart's method, you're suing them for breach of fiduciary duty.
Okay.
There is no trustee, so it's a little bit different.
It is a little bit different. Okay, I would have no problems with somebody being a trustee, but if you want to sue them because they can't provide their written delegated authority to actually be the trustee, you can go that route as well. People got to realize that once you understand what's going on, there's actually a million ways you can go with this stuff, because you are in the driver's seat. Your signature is what authorizes everything anyways. No one can come against you. I don't understand why people are creating all these tax shelter trusts. There's no need to, because everything's based on contract law anyways. Just the existence of your legal person doesn't create a tax obligation. I think that's kind of what you were getting at maybe with that. There's no need to create any other trust other than the express trust that already exists, which is your legal person. And as soon as that's why the videos, that's the concept I was trying to get people to understand. It's so important, which is the foundation concept of all this, is once you understand that you are the one that you own all the equity that's in the trust. You're the one that created it. You generated it. Your signature is God of that trust because you're the administrator. You're in complete control and authority of your life.
What do we call that? Knowing who you are.
Knowing who you are. That's what it is. And once you know who you are, the answers just pop right out to you. You know how to proceed in every instance. But it takes some learning. Unfortunately, like I say in one of the videos there, it's like I went to university for 4 years and got a degree in knowing who I am, and then people kind of come and they say, hey, awesome, can you teach me that in 2 hours? I was like, well, no, not really. Like, I could probably give you some of the concepts, but you're never going to understand it until you actually start to live it and start to
teach it to others.
Yeah. Yeah, unfortunately, that's the way it works. I mean, the knowledge is revealed to you. It's not something that you can just be told in an hour. But I don't know. Geez, it's kind of a vague question, but I hope I answered it.
No, I was just wondering, if there was another twist to it. I mean, I know what you're talking about is knowing who you are and what your role is on the trust.
Yeah.
Yeah, but I was just wondering if it could be changed when you're in the court, fighting the banks.
I'm not sure what you would want to change because as the administrator, you're the one that's going to be demanding documents from the person bringing a claim against your legal person, right?
Mhm.
So if you're the administrator,
you want to say that on your pleadings. You're saying you want to make yourself that on the pleadings.
I hate
say
doing
that a
things,
little bit different.
I hate doing things through the courts. What I like doing is I like defaulting people in advance. So if a bank's coming against me, I'm going to want to contact their solicitor in between hearing dates and say, hey, can you provide me with this and this and this and this and this? If you don't provide me with the original mortgage document, then we have agreement that you don't have it, that nobody does, that the bank is no longer the holder in due course, which means they have no claim. When they don't produce it, then you send in that document along with your motion to dismiss the charges or dismiss the claim or strike the claim from the record, whatever you want to do. You send in the document that you now have agreement. You have agreement with the other party. And the other party, what are they going to do? They're going to jump up and say, no, we don't have agreement. Say, well, then why didn't you produce the document? It says right here we have agreement that you're not the holder in due course if you don't present it to me, and you didn't present it to me. That sounds like agreement to me. If you have agreement of the parties, there's nothing left for the judge to make a determination on. Judges only handle disputes. If you have agreement, they have to act on that. That is law. Agreement, or a law is agreement of the parties. So get agreement from the party before you even go to court. And now there's nothing a judge can do about it. And like I say in the videos, agreement doesn't mean you agree with the person who's making a claim against you. Agreement means you get them to agree with you that they don't even have a claim in the first place. Now you have agreement when you go to the court. These guys have no claim. I have agreement with them. And then sue them for a frivolous and vexatious lawsuit.
Alrighty. That's
Alrighty.
good for you.
Thank you, Dean.
No problem. I hope it helped.
Yeah, I mean, just trying to see if there was another twist to that. Thank you. I appreciate it. And, great work.
Yeah, agree with thine adversary. Agree with your adversary. Agree with your adversary. Get agreement before you go to the judge.
That's super cool.
Okay.
Okay, thank you.
Thank you.
Okay, we're going to move on to Northeast Texas. Do you have a question for Dean Clifford? Northeast Texas, you're on.
Can you hear me?
Sure can.
Hey.
Can you hear
me? Is that you, Robert?
It is.
Yeah. Hi, Robert Fox. Meet Dean Clifford. Dean, Robert Fox is the one that sent me your link.
Oh, hi. Well, thank you.
Okay.
Robert Fox is a legend here in the United States.
Oh, awesome.
Truth seekers.
Yeah, a lot of the
Yes.
stuff from the States doesn't filter up here too often because a lot of people get confused with how to make it relevant in Canada.
Well, here's the interesting part for you, Dean. I was born and raised in Canada. I left when I was 30 years old. I'm 62 now, so I've spent over half my life in Texas. And I was very much interested in contacting non-slaves in Canada.
Well, now you got one.
Exactly. And down here, I've been a courtroom kamikaze for over 20 years.
Yeah, when I said earlier in the show there that a lot of the stuff we do is standing on the shoulders of giants, you're probably one of them because you've been in the fight a long time.
Well, I sent you, I have been in the fight a long time, and I was attacked by the feds not once, twice, or 3 times, 10 times. Trying to give me well over 100 years in prison. And have published cases in 2 countries and was cited in the United States Code Annotated and all that stuff. But and recently, more recently, I've been through a thing with the state cases. They brought 9 state cases against me, trying to give me multiple lifetimes in prison, and with over 3 years of litigation, they've got 0 victories.
The track record speaks for itself then.
Yes, it does.
I've been arrested well over 30 times.
Well, that certainly beats my record. I up here, of all the people that I know, I think I've been one of the most beaten up so far.
Well, I've been savagely beaten by these characters. At one point, they beat me so savagely that they broke my back and paralyzed me.
That's that sounds like a bunch of heroes.
Yeah, well,
yep.
they're a bunch of gangsters, of course. You know, they wouldn't have been, back in the day, confronted me, one-on-one, because I was there was one other guy who could lift a 285-pound unit like I lifted. There was only one other guy that could lift that from the ground and put it up in the truck level, 285 pounds, and I was the only one that could lift up a 375-pound unit. Anyway, but they wouldn't attack face to face, one-on-one, in a level playing field. No, they
never do. They're cowards. It's the gang mentality. That's the whole point.
Exactly. And anyway, your stuff is tremendous and just wonderful. I've been teaching people for all this time that everything is contract, and also I enjoyed it when you said that UCC is something they created for their benefit, not for everybody else's benefit.
Yeah, no, it's not ours. We can't force them to obey it. It's theirs.
Right. It was created by the shysters.
Yep. In fact, I think that even just filing most of this stuff, like a lot of the GSA forms that people like to sign, fill out and file with the government, and you got to remember, the god of the government is paper, mammon, right? Because what is money? Money is paper. Any paper that has value is something the government can use. The more we're filing with them of using their own forms, the more value we're giving the government. We're not helping ourselves. We're helping them by doing this. It's not a good thing to be filing all these documents with the government because it's their documents. They're not meant for us, right? And they need our signature. They need our signature on documents to live. So people are giving them everything that they need now and more of it. So we're making it worse by going and filing all this crap that we don't know what it's doing.
Exactly.
Yep.
So I wrote you a letter over a week ago, and apparently you still haven't gotten it.
Crap. Where did you send that to?
Where did I send it to?
If it went to the Free Manitoba YouTube account, then I didn't get that.
No, 276 Hugo Street North, Winnipeg, Manitoba.
Oh, geez, I don't even know what that is.
Well, where did I get that? I thought it was from your website or something.
I would be surprised if my address was posted on a website. That's probably something else. So, yeah, if you need my mailing address, if you want to contact me at, I'll give you an email right now.
Okay. Fire away.
Oh, actually, no. You know what? Go to YouTube and go to DCD OTCF. So it's Dean Christopher David of the Clifford family. So DCD OTCF. That's a YouTube channel. That's mine. And if you send a message to that account, I'll reply.
I still couldn't hear it right.
Yeah, like D as in Dean.
Yeah.
C as in Christopher.
Yeah.
O as in of. D. DCD. So D as in Dean, O as in, I can't speak right now for some reason, apparently. Dean Christopher David.
D or B?
D as in Dean.
Okay.
Yeah, I almost have to write this out.
All right, that was...
Yeah, D as in Dean.
Dean.
C as in Christopher.
Yeah.
D as in David. O as in of.
Okay.
T as in the.
Yeah.
C as in Clifford.
Yeah.
F as in family.
Okay. Fabulous.
All right, Robert, if you have a problem with it, email me. I'll give it to you again.
Yeah.
Okay.
Yeah, and then
Angela can share our numbers, our phone numbers back and forth, if you don't mind.
Awesome. I think she's on my Skype now too.
And
great.
It's just an immense pleasure to make contact with a Canadian patriot who's not a slave.
Yeah, I think that's one of the big things here is a lot of people are kind of digging the fact that I'm just not afraid of any of this. So more people need to be like that, and more people are being like that. So many people have stepped up now with the courage to say, yeah, you know what? If this guy can do it, I can do it. You know, F these guys.
Yeah.
So
we're a long time favorite. We've been a long time fan of Robert Menard, and what's her name? Gravenhorst, Irene Gravenhorst, and
I don't even know who that is.
Oh, they're Canadians that are right there.
Yeah.
In the thick of things. Robert, you don't know who Robert Menard is?
I know who Robert Menard is. Yeah, I've watched a couple of his videos online.
Oh, he's a great.
I like a lot of his theories.
But anyway, thanks so much, Robert. I'm sorry. Did you want to say anything else?
Well, I just wanted to say that I'd like to make contact on the phone privately as soon as possible, because I think I might have some kind of good news for you too.
Okay, now that was for me or for Angela?
For you.
Perfect. Then email me to that account I just gave you there, and I'll give you all my contact information, and you can even send me yours, and I can call you, not a problem here.
Yeah. Okay.
That sounds fantastic. Well, thanks a lot for the positive reinforcement on this.
Well, you're doing great. I mean, I think it's so wonderful. It's just absolutely fantastic. I mean, more people need to be out there and spreading this information. Myself, I kind of get bogged down with, private emergencies stacked one on top of the other, so I haven't been able to do seminars or the, it's almost tragic because you're of more benefit if you can, touch more people, and doing things one-on-one doesn't produce, nation-changing events.
No, well, I think we're doing that. I mean, as we speak here, I think by the end of the night, I'm going to turn 90,000 views on the videos on that on the Free Manitoba website. So, hey, let's get the whole world involved in this revolution. Let's go.
Are you familiar with Joe Girard?
I am not.
He sold Chevrolets and was listed in Guinness Book of World Records as the greatest salesman. And I read his book and attended his live seminar. And people would line up outside Joe Girard's office to buy a Chevy from him. And the thing that guided him was an interesting thing. He said a man dies, statistically 250 people attend his funeral, which means that one man affects 250 others. And if you treat the one guy right, you get 250 more that are, coming your way.
Yep. Well, it seems to be the case. You're pointing people my direction, so I appreciate it.
Okay. Well, all the best, and we'll be in touch here quick.
Absolutely. I'd appreciate that.
Thanks.
All right. Thanks. Nice meeting you.
Night, Robert. Okay, we're going to move on to American Eagle 1.
Hello.
Hi.
Hello, Angela and Dean. I've just watched all your videos, and I am, like most people, really amazed. I'm going to stay